24. No,
25.
25. Mr. H.I. Chaudhary, Learned Counsel, or Mr. G. Uddin,
Yes.
Learned Counsel for the petitioner, who submits that the proceedings before the Honorable Supreme Court of India in the connected matter is still pending and has not been disposed of. Accordingly, list this matter again after 4 weeks on a date to be fixed by the registry.
Oblige. May I please, Lordship?
Yes.
I beg to mention item 11, my lord, infrastructure, my lord. So, my lord, I want to inform. 11, my lord.
A&M,
My lord.
same. Your name?
S.A. Shikdal.
S.A. Sigdar.
S.A. Shikdal.
S.H. Sigdar.
Ma'am.
In front.
Okay.
Yes,
Okay.
madam.
May I plead the lordship?
Hmm.
Item number 24 of this list. The similar nature of cases is pending before this honorable court and which was fixed on 1/2/2024. The payment relates to non-payment of areas.
There are a few matters here.
Yes. So
There
this
are
matter
around
may be-
1, 2, 3, 4 matters.
This matter may be taken on with that matter dated WPC number 5225
5225
2016.
and fixed on 1, 2.
1.
I'll pass the orders when later. You need not be here. I'll pass. Yes.
It's the listing of a contempt petition, Your Lordship.
Listing matters, please give it. Yes, Mr. Bhuyan.
No, my lord, I beg to mention for motion listing, my lord, on Friday or Thursday.
What is the issue?
My lord, in one petition, my lord, we have challenged the order by which I have been relieved from the charge of the headmaster. In another petition, my lord, I have challenged the disciplinary proceeding. There is an order from this honorable court, my lord, that I should be reinstated first, then the proceeding should be initiated. But without reinstating me, my lord, proceeding has been initiated.
Friday.
Friday, my lord. All right.
My lordship,
Yes.
I beg to mention item 56, my lord. It may be upgraded, my lord. That NIOS matter, my lord, the uploading of mark sheet.
We'll reach, don't worry. We'll reach. If not at 2 o'clock, you make a mention.
Well.
Yes.
Lordship, I beg to kindly
Relax and say. There is no rush. Relax. Yes.
kindly allow this to matter for list. please.
Yeah, give it. Allow.
Oblige.
Don't get yourself tensed up when you appear in a court. Be relaxed. Others will not be able to say it. Okay? Yes.
Daily list, top of the list matter, item 1.
May I please, Your Lordship, my senior, Mr. S.C. Kalsa, he is out of station.
Have you informed Mr. Nath yesterday night?
Station, if you can.
Have you informed Mr. Nath yesterday night? Madam, have you informed?
We did not have his
then-
number.
How come you make this argument? A senior counsel is appearing. That much courtesy you don't have, that you inform him. This is not accepted, madam.
I'm sorry, Your,
These are small things you have to learn. You get my point?
yes, Your Lordship.
If you don't learn that, you will cut a very sorry figure. So not,
That's true. This is the system we follow normally. We always call up
this is not
the-
accepted.
Actually, we did not have his number in. the
You did not
petition
have his number,
as
don't
well.
make a mention. And why didn't you give me a note that you're not? That's the system. I'll not permit this 2000 top of the list matters to be adjourned like this. We have already heard the matter. Now for your Mr. Kayal and Mr. Chakraborty was to submit. We come prepared. Give us a note if you're not. I have enough matters. 1, 2 matters here, there, I have nothing to do. I'll not read. I'll devote that time to somebody else. This is the last time.
Yes, sir.
When is he coming back?
After a week.
We can't. You prepare. We'll have this matter on 6th.
Okay.
6th, I think 2, 3 matters fixed. Any
Well,
other-
you tell me a date.
Any date, any other date, except 6th, any date. Your Lordship convenient.
8th. 8th. And if he is not here, make alternative arrangements. So, a prayer has been made on behalf of Mr. S.C. Kayal, praying for adjournment of the matter today. Full stop. The matter was heard at length on the last date, and the date today was fixed. as per the request made on behalf of the respondents. Full stop. However, today, a prayer for adjournment is made without any intimation to the petitioner's counsel. Full stop. For the ends of justice, this matter again on 8/2/2024. It is made clear that no further adjournments in the matter would be granted.
My chocolate.
Item 2 and 3.
Yes,
May please your lordship. Well, a matter pertains to let non-payment of arrears salary, my lord, as well as current salary, my lord, despite of their service being regularized by the director, my lord.
Yes, sir.
okay. Your case is that you have been regularized in 2005. Thereafter, that regularization order has not been
Yes, yes.
interfered with, but no salary.
My-
Where is that similar order? They say rejected.
My lord.
Akramul Haq Chaudhary,
My lord.
Majumdar. Two option. Two
My lord,
WPC 2142/2009.
My lord, I am having.
You are okay, no need. Give me. But why this investigation of any fake appointment letters not been carried forward? It cannot be a general order.
That status, there is a communication by the finance department last.
I know that. Yes, Mr. Gugoi.
And that communication is part of 2005.
Five, huh?
And that too, that's a temporary order which was issued, madam, not a. Subsequent to that, what has happened, my lord, that's not very clear. Lordship may direct the authorities to verify, my lord.
Hmm.
Ah, Regularization 2005.
Similar order.
My lord. Ultimately, these petitioners are also from the same list.
Hmm?
Akramul, yes, my lord, in this, yes, my lord, the petitioners, my lord, herein are also from the same list.
It is inquiry here.
Same regularization order.
We are disposing it off
Well,
in terms of this communication.
individual representation, madam.
No, we will ask them that you had asked them that, the salary was stopped by the finance department on an apprehension that some fake appointment orders are there. Department will go ahead, make a
Yes,
scrutiny.
they may verify.
If they find,
Yes.
because they have already undergone a scrutiny anyway, a further scrutiny within a period of 1 month, if they find that they are there, in terms of the regularization order, they will be released their
Yes.
salary. The petitioners in the present proceedings. Claim to have been appointed as assistant teachers in various, both cases, same kachar.
Yes, yes, my lord. And that's out of the same regulation. list.
Appointed as assistant teachers of various SME schools in Kachar district in the year 1994. Also, there such appointments were stated to have been so done, so effective after the approval of the subdivisional advisory level advisory board. Also, the appointments of the petitioners came to be cancelled in terms of a communication dated 2012-1994 on the ground that the petitioners were appointed against non-existent posts. Also, the said cancellation of their appointments led to persons similarly situated like the petitioners to institute the CR, a writ petition before this court being CR number, civil rule number 32495
94, man.
94. Also, this court, wide an order dated 2195, directed that the petitioners be not ousted from their services, the petitioners therein be ousted from their services, and
My
a
lord,
direction was issued for release of their salaries.
Sorry, my lord, that is 95, my lord.
95.
CR, yes. CR case number, my lord.
32495.
Yes.
Also, it is projected that in pursuance of the said order dated 2195, the petitioners were reinstated in their respective posts with all financial benefits. Also, subpara. The cases of the petitioners were thereafter placed before the inquiry committee headed by Sri S. Manoharan, commonly known as the Manoharan Committee, for verifying as to whether the services of the petitioners were irregular or illegal. Also, on the basis of the inquiry report submitted by the said committee, the cabinet, by the cabinet decision dated 24/2/2005, the services of around 2776 numbers of teachers working at various schools appointed in excess of the post during the period 1/3/91 to 31/11/96 were directed to be regularized. Also, it is stated that the names of the petitioners figure within the said list of 2776 numbers of candidates, teachers. Also, accordingly, while an order dated 31/3/1995, the services of the present petitioners were regularized, where the services of the petitioners were regularized with effect from
20 regulation order, my lord.
regularization order is at page
22, my lord.
Huh?
22, my lord.
20, sorry, by an order dated 28/2005,
Yes, my lord.
the services of the petitioners were regularized with effect from the date of their joining against the vacant posts as indicated in the said order. Also, the petitioners claimed that after such a regularization of their services, they are continuing to discharge their duties, but their salaries have not been released till date. Also, being so aggrieved, the petitioners had instituted the present proceedings. During the hearing of the present proceedings, Mr. P.K. Bora has placed on record an instruction received by him on 29/1/2024 to the effect that wherein the services of the petitioners have been admitted to have been regularized with effect from the date of joining by the said order dated 28/2005. However, it was brought to the notice, it was stated in the said instructions that the salaries of the petitioners could not be released on account of a WT message of the finance bracketed budget department to the Deputy Commissioner Kachar with information to the Treasury Officer Kachar to the effect that it has come to the notice of the Finance Department that take appointment of teachers in Kachar district has been made on the strength of the cabinet decision dated 24/2/2005 with reference to the recommendations of the Mahanaran Commission, and accordingly it was stated that the decision that it stated that not to entertain the salary bills of such teachers, such teachers appointed in pursuance to the said cabinet decision of 24/2/2005. Also, it is contended that it is on account of the said direction of the Finance Budget Department that the salaries of the petitioners have not been released. Also, it is seen that the said WT message was so issued on 7/10/2005, and thereafter no exercise has been undertaken by the respondent authorities for verifying the appointment status of the petitioners. Also, the said WT message was so issued on an apprehension that certain fake appointments were effected in Kachar district in pursuance to the said cabinet decision. Also, it was open to the departmental authorities to verify from records as to whether the appointment orders of the petitioners, including the order of regularization issued in their respective cases, were so issued basing on materials available on record and was so issued by the departmental authorities. Also, there being no dispute that the petitioners' services were regularized as far back as 28/2005, the salaries of the petitioners could not have been withheld for the last around 19 years. Also, in view of the said position, this petition is disposed of, directing the Director of Elementary Education, Assam, to verify the service status of the petitioner and also to verify as to whether the petitioners were included in the order dated, were included within the list
Regulation
of 2776, no?
Yes, yes.
2776 numbers of LP/ME/MEM/HS/HHS teachers who were required by the decision of the cabinet to be regularized in their services. Also, on arriving at conclusions with regard to the service status of the petitioner on the said grounds, the Director of Elementary Education, Assam, shall pass appropriate orders towards the release of the salaries of the petitioners, which is stated to be pending with effect from the date of their respective, from the date of regularization of your services, that is with effect from 28/2005. Also, the inquiry as required to be carried out in terms of this order shall be carried out by the Director of Elementary Education carried out and concluded by the Director of Elementary Education, Assam, within a period of 2 months from the date of receipt of this certified copy of this order, along with a representation from the petitioners. Full stop. On conclusion of the inquiry as required herein above, it is found that the petitioners have been correctly regularized in their services while the order dated 28/2005. The current salaries of the petitioners shall immediately be released. Also, with regard to the areas of salary pending with effect from 28/2005 till the conclusion of the inquiry as required above, shall be released to the petitioners within a period of 6 months by the respondent authorities. Full stop. With the above observations and directions, the petition stands disposed of. Second, Wallaby.
Same like.
This also regulation
Same, my lord.
28,
Out of the same said list.
28. Disposal.
My lord.
A copy of the communication dated 29/1/2024 received from Mr. Bora, PK Bora, is kept on record and marked as X. K Khalia, 5698 में करिए.
Obliged, obliged.
Disposal.
Item number 5,
बिल्कुल ready. Okay, paragraphs two. Yes,
Lordship, here the petitioners were initially engaged as Lordship saying,
Okay.
saying man in honorarium
Okay.
proceeding.
what is there today?
Lordship,
What is there today?
they may be selected and to allow to.
No, they will have to appear in that examination.
No, Lordship, they have got exemption, therefore, because they have already, as a chainman, they have worked more than 8 to 9 years, so their names were forwarded, Lordship, at Annexus C, page 17. Because of that only, their names were forwarded.
Yes, Mr.
Lordship, this is the first time I appear, Lordship. Lordship, may I kindly go to the page 17, Lordship,
Okay.
and
that's it.
exercise C. They are not working as a regular employees, Lordship.
Yes,
Yes, they were engaged as on honorarium basis, Lordship.
honorarium basis, then if they are like general candidates, they are not the normal chainmen.
Because there are.
You show
there
me
is-
the law that chainmen can be set.
Lordship, in their affidavit, it is there.
Okay.
In the
tell me.
affidavit filed by the respondent number 2.
Two.
Paragraph 6,
Phone number?
page 4, Lordship.
9. ठीक है, फैल रहा है.
May I read, Lordship? Paragraph 6, Lordship.
Hmm.
Clause 1, a person passing the 6 months recorder certificate class course training from Assam Survey Settlement Training Center is eligible to be appointed as a Mandal recorder. Rule 15 of the Assam Survey and Settlement Training Center Rules 1992 says that the object of the RCCC training course is to train candidates in the duties of Mandal/recorders. The minimum educational qualification for admission.
Okay, this is with regard to chainman, regular chainman.
Regular chairman, Lordship.
Show me that you are a regular chainman.
Because of that, Lordship, I.
This is a very
Yes.
attractive training. I know that. So you show me that you are covered by this.
Lordship, considering my eligibility, my case was forwarded, Lord.
No. That may be
But
done.
in the affidavit.
But you
also-
show me that,
In the affidavit at page 9 also, the reason for rejection is, Lordship, they have stated that the documents were not forwarded. Page 7, Lordship, their affidavit. Paragraph 9, page 7. Paragraph 9, page 7, Lordship, that may be paid. The reason for non-selecting is that the documents were not forwarded.
okay, fine.
But those were already forwarded in the affidavit filed by the deputy commissioner admitted, Lordship. By the respondent number 3.
Do one thing. You submit an application before the director of land records.
Even the Lordship, my Lord,
Lordship.
that, Assam, my Lord, that Survey Settlement Training Center rule, it is a very repeal, Lordship.
Repeal.
Lordship.
Hmm.
Lordship, may I kindly go,
And how is the training now given?
my Lord, that they have to appear in the, well, the selection process, then my Lord, can, my Lord, go for the training. And my Lord, that, and earlier, my Lord, it was the. Lordship
It was
the
that
mandate
selection, then five vacancies each year was given to
Yes,
chainmens.
Lordship.
yes,
And that too regular
Earlier-
chainmen.
Earlier, Lordship, it was the matriculate. Now, my Lord, he have to, my Lord, graduate.
Lordship, in terms of this, since the case petition was filed, Lordship, prior to the.
No, we can't. We'll have to go by the latest one.
Lordship, they'll file representation before, and if the, after verification, if they are entitled, then may Lordship consider, because the case has been pending since 2013, Lordship.
Fine, but this has come in 2023.
Lordship.
Today, why did you get this matter last listed in 2014? What prevented you from making a mention, getting this matters listed and doing it? You can't blame the court for that.
Lordship.
Then last listed on 21/4/2014. No interest. If you were so interested, you should have pursued this matter. And there is no statement that you had made a prayer. Make a statement that you had made a prayer on such days this court did not permit you.
No, Lordship.
This court will never.
Last but second, Lordship, my lord, that terms and condition, my lord, for the application. My lord, it is given over what the percentage and my lord, the qualification is given, Lordship.
The petitioners who claimed to be engaged on honorarium basis in the office of the circle officer, Naudua Revenue Circle and Tezpur Revenue Circle as chainmen have raised a grievance in the present proceedings with regard to non-consideration of their cases, in spite of recommendations made, for selection for undergoing training for the Recorder's Certificate Class course also conducted by the Director of Land Records and Survey, Assam. Also, it is projected in the writ petition that the cases of the petitioners were forwarded by their respective deputy commissioners to the Director of Land Records and Survey, Assam, for allowing the petitioners to participate in the said RCC training, in the said training course. However, for the delay in processing such matters, the cases of the petitioners could not be sent up for training, accordingly, because of the delay occasioning in processing of their cases by the authorities, the petitioners could not be sent for the said training course. Also, Mr. J. Handick, Learned Standing Counsel, Department of Revenue, has today placed up before me a notification dated 27/3/2023, by which has placed before me a rule called the Assam Land Records Subordinate Service Rules 2023, and has contended that the Recorder's Class course training program shall now be conducted in terms of the provisions of the said rules of 2023 and the earlier procedure orders that were in place have and the said rules of 2023 has repealed the Assam Land Records Manual, as well as the relevant rules and the rules corresponding to the present rules of the Assam Survey and Settlement Training Center Rules 1992. Also, in that view of the matter, this court is unable to require the consideration of the cases of the petitioners in terms of the recommendations made in their cases way back in the year 2012. Also, however, the petitioners in the event they are found qualified under the provisions of the Assam Land Records Subordinate Service Rules 2023, may be permitted to undergo the said training course strictly in accordance with the provisions of the said rules of 2023. Also, for the above purpose, the petitioners shall submit individual representations highlighting their claims to undergo the said training before the Director of Land Records, Assam,
And survey.
and Survey Assam, along with a certified copy of this order. Also, on receipt of such representation by the Director of Land Records, Assam, he shall consider the claims made therein by the petitioner strictly in accordance with the provisions of the Assam Land Records Subordinate Service Rules 2023 and or any other order oblique rule in force with regard to the conduct of the Recorders Class Course Training Program. Also, the Director shall consider and dispose of the said representations of the petitioners within a period of 1 month from the date of receipt of such representation along with a certified copy of the order. With the above observations and action, the petition stands disposed of.
All right,
You can take back your rules.
Lordship.
Lordship, I appear for respond numbers 3, 4, 5, and 6.
Mr. D. Bonner appears for the respondents number 3, 4, 5, and 6. Mr. Andy,
1 and 2. Lordship.
1 and 2.
Oblige, Lordship.
Item number 6.
Mr. Chaudhary, what is left here? He wanted a framing of rules. And by this time, he has also retired. I've seen it, there is nothing in it. 57 in 2013. Having a peaceful retired life, let him have it. None appears for the petitioners on call. Stop. Accordingly, this matter stands dismissed for non-prosecution. If they come back, if they have any something, let them file an application, we'll consider.
Lordship.
Item 7.
May I please, your Lordship?
Hmm.
In this matter, my lord, petitioner is working as a constable under 9th APPN, Brahmpur, Nagaon, my lord.
Hmm.
So, on 9th May 2006, my lord, commander has issued a letter, my lord, asking to submit a WS in defense of within 10 days of the allegation was that he was remained unauthorized absent from 31/10/2005 to 22/3/2006, my lord. Total 141 days. He was unauthorized. He was leave, my lord. He was on leave. Then, my lord, petitioner has submitted a written statement, my lord, to the on 7 June 2006, my lord, that he was suffering from a chronic bacillary dysentery, a sickness, my lord, and the commandant was not satisfied with the reply, my lord. So he has drawn a departmental proceeding against the petitioner, my lord. So after that, my lord, an inquiry officer has been appointed and report was submitted on 31/5/2009, my lord. Numbers of witness has been examined and medical report was produced, and the statement of the petitioner could not be taken because he was again untraced from the place of posting. So the inquiry continue as ex parte, my lord. And so another on order dated 18/7/2008, my lord. During inquiry, another SOCOS notice with additional charge has been issued, but he has not received the letter, my lord. So inquiry officer came to the finding that the charge brought against the petitioner is not proved. Actual charge could not be sustained, my lord. And then, my lord, on order dated 36/2009, respondent for it is the commandant, my lord, has discharged the petitioner from service with immediate effect, my lord. So I was unauthorized absent from 25/11/2006 to 12/10/2007, my lord. And then there were 3 deaths, my lord. I've stated in the paragraph, my lord.
Okay. So your case is
penal
that
charge
as it
is,
has been held to be not proved,
my lord,
so you're not to be, not to have been
my lord,
terminated from your
my
service.
lord.
Have you read the affidavit filed by the authorities?
Yes, my, yes,
Your case is that you have not received the additional charge sheet.
yes, yes, my
Huh?
lord, yes.
Come to page 5 of the affidavit. What do you have to say on this? Para 12.
Paragraph 12, my lord. That with regard to the statement made in paragraph 11 of the petition, the deponent beg to state that the so-called notice of additional charge was issued by memo number 9 RDP 2008 9505 dated 18/7/2008, which was duly received by Srimati Santi Bora, mother of the petitioner. Yes, my lord.
Then
Yes,
you
my lord.
don't participate
Yes,
in that inquiry. Then how can you come back and say that I did not receive it? Go further.
my lord.
Come to page 6, para 14, last line.
With regard to the statement made in paragraph 13 of the,
Come to the last line of that.
my lord,
The second show cause.
my lord, second so-called.
3 lines from bottom
The
of that.
second SOCOS notice issued with wide memo number, my lord, dated 5/6/2009 was also duly received by the petitioner by putting his signature in duplicate copy.
Where is your response to this? Have you denied these statements? This affidavit was filed in 2013. We have now literally 9 years,
My lord,
10 years.
10 years,
You have not disputed this. How can I proceed further?
my lord.
Anything more? Anything more?
No.
What should I do?
This is,
Thank you. The petitioner in the present proceedings, while functioning as constable under 9th ATPM Barampur, was issued with a show cause notice dated 19/5/2006, wherein it was alleged that he had remained unauthorizedly absent from duty with effect from 31/10/05 to 22/3/06 for a period of total 141 days without leave and or permission. Also, the petitioner, in response to the said show cause notice, had submitted his written statement of defense and therein had brought in on record that the said absence was not deliberate, but on account of ailments suffered by him. Also, not being satisfied with the reply as with the written statement as submitted by the petitioner, the disciplinary authority instituted an inquiry into the matter. Also, the petitioner, the inquiry officer, after having considered the evidences coming on record and also taking note of the medical certificates as produced by the petitioner, which were verified by the doctors appearing in the inquiry, proceeded to hold that the charge of unauthorized absence as leveled against the petitioner is not proved. Also, what is to be noted in the present proceedings is that during the pendency of the inquiry proceedings, the petitioner did not participate therein in spite of repeated notices, and accordingly, the petitioner was issued with an addition with a further show cause framing an additional charge against the petitioner. Such show cause was issued by the disciplinary authority on 18/7/2008. The said show cause was received by the mother of the petitioner on 16/8/2018 in the presence of witnesses. Also, the petitioner not having participated in the inquiry in pursuance to the said additional charge frame instituted in pursuance to the said additional charge leveled against him, the inquiry proceeded and the inquiry officer submitted his report holding that the additional charge leveled against the petitioner for the unauthorized period of absence has been proved beyond doubt. Full stop. On receipt of the said second inquiry, of the receipt of the said inquiry report, the disciplinary authority issued to the petitioner a second show cause notice on 5/6/2009, and it has been contended by the respondents in their affidavit that such second show cause notice was received by the petitioner when under his own signature. Full stop. The said aspect of the matter about receipt of the additional charge framed by the show cause notice dated 18/7/2008, as well as the second show cause notice dated 5/6/2009 has not been disputed by the petitioner by bringing on record any pleading to that effect. Also, the petitioner in the present proceedings has assailed the order dated as by way of instituting the present proceedings, assailed an order dated 13/6/2009 issued by the Commandant 9 APB and Borampur, Nagaon, discharging the petitioner from service with immediate effect. Baki ki nahi to ek hai. Also, the petitioner in his present proceedings has not disputed the fact that he had not participated in the inquiry and inquiry in spite of being issued notices for such appearance. Also, the petitioner has not brought on record any explanation as to why he had remained unauthorizedly absent for the periods mentioned in the additional charge level framed against him while the show cause notice dated 18/7/2008. Also, the petitioner has also not raised any grievance with regard to any deprivation meted out to him in having his case, in defending his case in the said inquiry. Also, it is the case of the petitioners that the petitioner had abandoned his services without any information, and in spite of the fact that in the earlier proceedings, on account of the medical certificate brought on record and the medical evidences coming on record, the charges leveled against him were held to be not proved. But there is no material brought on record by the petitioner to justify the period of absence as alleged against a period of absence held to be unauthorized by the respondents in the show cause notice dated 18/7/2008. So, in the above view of the matter, and also considering the fact that the petitioner is a member of a disciplined force, such conduct of the petitioner is not acceptable. Also, it is to be noted in the written in the writ petition, although the petitioner had received the show cause notice dated 18/7/2008, as well as the second show cause notice in pursuance thereof dated 5/6/2009. There is no reference to any of the same in the writ petition, and the petitioner has even not brought on record any material, any pleading in response to the affidavits filed by the respondent authorities denying the said aspect of the matter. In absence of any such categorical denial on the part of the petitioners, the contentions as made in the affidavit in opposition filed by the respondents, more particularly to the proceeding as initiated with by the addition with regard to an additional charge while the show cause notice dated 18/7/2008 and the conclusions reached therein by the inquiry officer and the penalty so imposed upon the petitioner has to be accepted. Also, in view of the said position, this writ petition is held to be without merit and the same accordingly stands dismissed. However, there would be no order as to cause. You had a very good case, but your conduct took it away from you. No statement in the writ petition. I scanned twice. If you get it anything pertaining to that second inquiry,
My lord.
not signing the order.
Hello.
You come back at 2 and tell me. I'll revise my order, no problem. I have not found anything. If there is anything,
No, no, my lord.
anything is there, come back. I'll
No,
still
no.
give you a hand up.
No, no, my lord.
Then,
all right.
sorry.
Deeply obliged.
Item number 8,
May it please your lordship. My lord, this time before your lordship, he was a police constable. And
We are now with item number?
Eight.
Eight,
Eight.
okay, okay.
Annexure 1 is the my lord at page 13, my lord.
Okay,
The-
yes,
That was the search, my lord. Page 13 annexure 1. my
okay,
lord.
okay.
Then, my
That
lord-
case, wherein the criminal case, he was,
Criminal case, he was acquitted by the appeal,
Division
honorably
bench.
acquitted, my lord.
by this court.
By this court. And my lord, your lordship kindly see the inquiry report submitted, my lord, that,
We'll go from the charge, Mr.
yes, my lord,
Page 14.
page 13.
Okay. 14,
Page 14 is my lord,
a charge.
charge.
You used to visit the house of so and so, so and so, so and so, so and so. You consider yourself to be unmarried. Place not only to you. Okay,
You are here therefore charged with the misconduct, indiscipline and negligence of discipline. These are the three charges.
Mm.
Level
we'll
against
have
you.
to read that paragraph before that also. Being a member of the discipline post, you have to act in such manner which is disgrace not only to yourself but also to the entire police force and render yourself unfit to be retained in the service.
That is- So that's
You are therefore charged with so and so.
my lord,
This is of 23/9,
2003.
2003. Of course. Okay,
Then my reply is my page 16 annex 3.
Hmm.
A short reply, my lord, I have filed.
you have referred to that judicial proceeding. Basically,
My lord,
denying the charge and then saying there is a case pending against me.
yes. Now,
Now-
my lord, your lordship kindly see
19.
page 19, my lord. And
Hmm.
my lord, the 17, my lord, I have filed an application. Means there is a criminal case pending
Hmm.
and the charges are same, so that department proceedings should be stopped.
Stop.
But that was not stopped. So that was my application, page 17. Then, my lord, page 19, my lord, is the inquiry report, my lord.
Okay.
So your lordship,
The witnesses basically are
Same.
the victim, purported
and
victim,
and the doctors,
and the doctor and the
Doctor.
nurse.
my lord.
Okay.
So your lordship kindly see the last line, where only one line, my lord, they are finding, my lord, given, my lord, one line. So from the inquiry, it held above, page 21, my lord. The above examination witness is found that the allegation brought against the so-and-so, so ABC so-and-so is proved.
This
So where
is
is the
dated,
finding regarding misconduct? Where is the finding, my lord, indiscipline? There is
Okay.
not a finding against the charge, my lord.
okay.
Not a single line, my lord. Or
Come to
simply
page 27. I got it, mister.
my lord,
Second show cause notice, then page 27.
page 27, my lord.
Hmm,
That is the order, my lord, first in appeal, my lord.
hmm.
No, that is the order impugn.
Impugn.
Impugn, my lord.
Moral turpitude.
During the inquiry, department proceeding inquiry,
Last line,
last line.
page 27. I have come to the conclusion that the police personnel, like the delinquent of the character of moral turpitude, may bringing gloom to the life of the victim,
My lord,
should not be retained in the police department.
my lord. I agree, my lord. So then, my lord, I file an appeal,
This is 1/8/2005.
my lord.
Penalty is discharge, no?
That is removable from service. Yes,
Removal.
remove.
Then
Then,
you
my lord,
prefer an appeal.
appeal, my lord. So appeal is also same twin, my lord. I have all the point I have urged, my lord, regarding my lord, because I have not crossed the, my lord, evidence before the inquiry officer, because if I cross, then I will disclose my defense in the criminal case. That's why your lordship kindly see all the witnesses I have not crossed. And appeal I am clearly stated that, my
No,
lord.
no, the witnesses, those witnesses which have been brought on record in the inquiry report,
my lord.
other than the PW1
PW1 the
victim and PWD2,
Uh,
the PWD3, 4 have not
said anything,
connected
except-
you and that lady.
My lord,
They only say about a fact
facts.
of delivery and of delivery basically. Respondent of PW3 and 4 are basically with the delivery by the victim of a boy,
My lord,
right?
my lord,
Only 1 and 2.
my lord. So, in my appeal, my lord, I have said everything, my lord, that was even not considered, my lord, that is been rejected. Then, my lord,
Now, Mr. You were convicted on which date?
8/2/2006.
Mr. Montauk,
My lord.
this court literally let you go because the ingredients of 376, although you submitted that 417, 4 months I have undergone, I should be allowed to, that
No,
should
that
be
is in respect of 417.
417. You made that submission, but this court said nothing doing everything.
Everything.
But this court did not say that you both did not have a relationship. It was a consensual relationship. That would be the court did not say that the allegations with regard to 376 and 417 not proved.
My lord. So then whole case goes.
No. Still, the consequences, it may be consensual, no
My lord,
problem.
My lord.
But a police officer committing that act, is it not against the conduct he is required to follow?
My lord,
You are only claiming that because the criminal case is
No.
gone, I should be, see,
No.
this is not the case before the charge. The charge is different against you. Being a member of the discipline force, you have acted such manner which disgrace not only yourself, but also the entire pool and render yourself unfit. Now, the
No.
allegation is you used to visit our house, leaving the place of posting without any leave. You pretended yourself to be married, cohabited with so-and-so, with inducement of marriage. As a result, she became pregnant and gave a birth. Here, in the criminal case, just correct me, this is the doubt I am having. In the criminal case, not forceful, consensual relationship. That's what is evident from the criminal.
that is why I could tell. No, another finding is.
I
there.
want your answer on that.
Another submission, finding in the criminal case, my lord. There is an agreement. I said that this is the son not born out from my side. That why by force they taken me signature in a form that I will pay maintenance till he's been this.
Paternity test is.
That is not been done because, and that was the considered by the. So yes, I used to visit. That part is your lordship wanted to say that yes, that part will not covered by the judgment, my lord. That's why it is been acquitted. So my lord, I have.
No, even the judgment does not say that you both did not have a relationship.
But charge level against me has been.
376, 417 gone. No
My lord.
problem.
No,
But
if 470 and 47 gone,
gone,
then criminal case absolutely gone.
gone.
But so far is my lord.
But the
Yes.
relationship still,
My lord,
that
visit
is not.
somebody's house is not, I don't think,
No,
because
no,
I without disturbing, because there is a in absence of duty. There
That's
is no
what-
finding.
That's what, Mr.
There is no finding because
No,
in
no.
my duty hours that is not been done.
No,
Not a single,
No,
not a
what
single
has
instant that I have not been present in the office.
I got it. Only thing that I want to know is, you did not cross PW1.
Why? Because if I cross, that's why then I have taken in the appeal. If I cross, then my lord, my defense in criminal case will be disclosed.
No.
So that's why I cannot take my lord that plea.
There are decisions against you.
My lord,
You
that-
should have come up before this court and got a stay on that disciplinary proceeding.
But yes, I filed an application, but that was not done, man.
Not done, you should have come here.
That's why.
You know that better.
That's why I keep mum. No, I got your point, my lord, that part. But even that, my lord,
I'm sorry, I'm interpreting you. One more point. This penalty is of 2005.
my lord.
It has attained finality. Now, how can, with this order, which does not give you a clear picture, although the charges you have been acquitted
My lord.
one way, but it does not acute you from that essence which is there in the criminal proceeding.
Is it
In
so
the-
grave that any removal service?
That's what I'm asking you. 2005, why was that not put to challenge immediately? You
That-
accepted it.
That part, my lord,
You accepted it. You waited till the criminal proceeding is there. The criminal proceeding had gone against you. You would
My
not have made a challenge to this.
that's true, my lord.
Independently, it has to be
Yes,
challenged.
yes, that independently that was not been said.
So these are the two queries now satisfied.
No, that, my lord, for ignorance, he is a constable, he is not an officer, my lord. For that reason, my lord, we should not be punished, my lord.
Okay.
Because the whole, your lordship kindly see, the main given is, yes, this is a case of 376, and because in my reply, I have made a statement that child is not born out of me. It's a clear reply I have given. So in at least, my lord, learned, my, that means inquiry in officer should have, my lord, gone to that, my lord. They did not even, my lord, produce the medical certificate, my lord. My lord, doctor was examined, but medical certificate that was not been even exhibited in inquiry.
Okay, I got that. That everything agreed. Only satisfy me with that basing on this criminal appellate court judgment, the disciplinary authority's order removing you has to be interfered with.
Right.
1. 2, if that is to be done. 2, second question would be that order being of 2005 and the writ petition being filed
2013,
13
after acquittal,
after 8 years.
after acquittal, yes.
Why that order should be
So
interfered.
immediately, my lord, what I am submitting, immediately, my lord, getting the acquittal in the criminal case, I file a application before the authority, revoke the order.
Hmm.
Then, my lord, there's a reply from they did not give any reply, but from the affidavit they filed, I got the reply that because there is no system, that's why I've done nothing. When there is, my lord,
Pradip Chandra Solo is no. Numal Mohanto's affidavit.
SP,
SP certificate. Para 9, they say you were removed on 1/8/2005, earlier to the judgment passed by the Honorable Court on 31/2013.
Mhm.
Because in the disciplinary proceeding, Mr. Monto,
my lord,
there is no reference to the criminal case.
criminal case.
It is an independent finding.
No,
If it
that's-
would have been that you were convicted by the trial court, then this as occasion, situation would have been different. I want only 2 answers. 1, how to open that order with this key of the appellate court, criminal appellate court. If that is permissible, then the delay.
The delay, my lord,
I would
already-
require judgments, Mr.
let me, my lord, find out on that delays,
You do it.
my lord.
Interesting.
Otherwise, my lord, no.
Because a technical thing is before me and I can't ignore that. Because a matter which has
No,
attained
that's
finality,
in because, my lord, I should have opposed this honorable court by 2006. or 2005,
independently you should have challenged that.
Before passing the judgment by the High Court.
Ah, you should have. Because you have, because there is nothing there connecting to the criminal case. It's a proceeding independent in itself. And Supreme Court judgments are there.
No, that's the, see.
Tank, if you will bring in JM Tank. There is a latest judgment in Ramlal.
Yes, that I have, my lord. Yes, that.
Ramlal would be
Yes, Ramlal judgment I have, my lord. Yes,
2023,
yes, Ramlal
1
judgment.
SSC 598.
Yes, page 27, my lord.
Para
para
23 and
27.
23 and 26.
Yes, that is judgment with me, my lord. Yes. that I-
Mere acquittal by a criminal court has no impact on the disciplinary proceedings.
But your lordship kindly see para 27 of that judgment, my.
Yes, yes.
Page
Good,
27.
good,
That I am
good.
relying also. I am going to rely on
Oh,
that judgment. also.
Good. Para 27, let's check that.
We are additionally satisfied that the teeth of the, no, here in this case, my lord, that is, he has been given, Lord. Honorable High Court, single match, dismiss, it appeal, this.
Interpret that for me. Apply it to your case. Para 27.
Paragraph 27. That we are additionally satisfied that teeth of the finding of the appellate judge in disciplinary proceeding that the orders passed thereupon cannot be allowed to stand. The charges were not just similar, but identical in evidence. So not similar, my lord, identical
In evidence.
in evidence. Witness and circumstances were all the same, that there is this case where the exercise of this discretion, we quash the order of the disciplinary authority an appellate authority is allowing them to stand will be unjust, unfair, because this case is so. So, my lord,
You can argue that in the criminal case and in the disciplinary proceeding, the witness was one, that is the victim.
victim, my lord.
Others were not there. Others were just
Other one only hearsay,
cosmetic,
they're hearsay,
cosmetic.
my lord. So that's why, my lord,
Now
that-
you show me this thing, 2013 order. How do I let it operate of an order passed by a disciplinary authority without reference to the criminal case in 2000?
no, that's my, I admit it, that's my lab there, because probably, my lord, I'm submitting, my lord, when my lord criminal case is pending, a constable, my lord, he always think what has go, whether he'll go to jail or he'll for service.
You find out
that's
some
why
judgments on
The
that line.
delay, my lord, delay
Give
part,
me,
my lord.
I'm open.
No,
Because
in
I
that-
also
that
have my
aspect, my lord, no, now only in delay part.
delay and this judgment.
The judgment 20, that is the latest.
Thank, you apply with your findings. Because see, Mr. Monto, don't forget the allegation against you in the disciplinary proceeding. It's not rape. It's not 417. It is a conduct of yours, which is there in question.
My lord.
So with this, how do you demolish that? Rightly, wrongly, there is a finding against you, and that has with
No,
time.
Except that, my lord, not present in duty, and there is no finding whatever. Your
It's a
lordship-
presumptions. We'll
your
not
lordship-
even go into that.
But on conduct,
Conduct. The allegation, the statement of PW1 stands. And see, PWD1 statement also stands in the disciplinary, in the criminal case also. But
but
to the extent of 376 and
no,
417.
that your lordship kindly see in my reply, my lord, I have stated one line. Yes, I am a married man, she knows.
That's it.
I know she
When do
knows.
you want it? Tell me one more date. When do you want it? I want us satisfied because I'm not satisfied. That's why I'm not proceeding with the matter. I want assistance from you.
My lord,
When? But this is the lock now.
my lord, that is two.
This
two
is the
areas.
lock.
All right, my lord, I'll trust my lord, I'll try to find
We'll
out
have it on 6th.
my lord.
Third in part. List again on 6/2/2024 for further hearings. Mr. Bora, find out.
Your lordship,
Because
also-
if Mr. Monto can satisfy me that the criminal case findings, appellate court findings is enough to demolish the witnesses or evidence coming on record in the disciplinary proceeding by referring to Ramlal, maybe I'll have to come in his favor.
your lordship,
But again, the question of delays. Find out that this has attained finality, it cannot be reopened. Something is there to me.
also, in terms of Ramlal judgment, para 11, 10, 10, 11 and 12, your lordship.
Hmm.
10, 11 and,
10, 11, huh?
no, sorry, so para
10,
11,
11,
12,
para
and
11,
12,
para-
13,
yes, yes, huh.
which says the legal position.
Hmm.
Lordship, if.
It deals with the legal position initially, then it goes and applies
Then
in.
it goes.
Now, see the application also.
Yes. So
That
the
legal
fact of
position that has been there, it's vague. It encompasses a lot of factors.
Lot of.
That is why I was having a deliberation with Mr. Monto with regard to the purport of the criminal court judgment.
And
See,
your lordship, also, if I may request my learned senior to actually give me a copy. because
he'll,
of
you
this-
take a copy from him, he'll, or Mr.
required-
Junior will give you a copy. No?
Because the brief is missing.
Okay, I'll give you one set, my lord, with you. No problem. No problem.
Mr. Monto, please,
Yes, definitely,
you get me something.
my lord.
This is the law.
I understand, I got that point, my lord, yes. But delay, so far as delay point, is concerned, my lord, I have no role to play because.
No, there,
No, no, I'll try to
whether
satisfy.
that
the-
delay
on the-
can be ignored when when a criminal court has acquitted you. That should be the approach.
Yes,
Remove that preliminary tentative thought.
I know. I'll try to satisfy you, all right,
Item 9.
He is still paying 1,000 rupees.
my lord.
He is still
No,
paying
no,
1,000.
probably I don't know that part, I don't know, man. But DNA is not done.
Eh?
In spite of my repeated request, DNA was not done.
Done. Okay,
And then because of not paying, she complained later on.
I got it.
It was very afterward, my lord.
That
So
again,
I
again-
stopped
no, no,
paying.
for a criminal case, that was good. But when it comes to the,
No, there is a
conduct in
finding
the-
by the, there is a finding by the, our appellate court
I know
judgment.
that. When it comes to the disciplinary proceedings, it becomes a misconduct indication of misconduct against you.
My lord.
That line,
I am not paying 1,000 rupees. That's why my lord FIR was lost.
but that shows that you had a relationship.
My lord. No, my lord, I understand. I have a relation, but it is so game, my
And
lord.
I'll also do my work. I was doing it. I'll also
My-
examine, don't worry.
May it list.
Yes.
Infractions, my lord.
Oh. Arikata East
Yes, my lord.
on the prayer. Mr.
R. Islam.
R. Islam, Learned Council for the petitioner, submits. Heard Mr. R. Islam, Learned Council for the petitioner, also heard Mr. D. Bora for the respondents. Mr. R. Islam submits that during pendency of the proceedings, the issue raised in the petitioner has been appointed.
No, my lord. This advertisement was issued, my lord. Another person was appointed.
Also, submits that in view of the subsequent developments taking place in the matter, the issue raised in the present proceedings has become infructuous. Also, and there is nothing to be adjudicated as on the, in terms of the above, where the writ petition stands dismissed as infructuous.
Obliged.
Item 10.
My lord,
Yes,
lordship may kindly pass by because my lord, I could not contact the petitioner whether he is next week, my lord, any date I'll do, my lord. Because last
clear case of abandoning of services. His first plea was very attractive. Wife died, so I'm in a mental shock. I have a 2-year-old child. Thereafter, the report comes from the OC. He is married, has another child. He is doing business in the village and also carrying out agriculture activities. After that, what is that? When do you want it?
next week, maybe on 12 or 20.
On the prayer by Mr. So list this matter again on 8/2/2024.
Publish.
You examine. I don't think so. there is any.
Publish.
Your Lordship, if I may request your lordship, there are 2 copies of the affidavit in the first file itself. If I can actually have it put in the second file, your lordship, then I can
Okay.
actually.
Second file of 280. Second file ascend here. We don't have a
In-
second. It's all in the first
It's all
file.
in the first file.
You can have the copy. He'll give you a copy. You can Xerox it and give it back.
Yes.
Xerox put it in and do it.
Publish.
On 8/2.
Item 12.
Yes, who appears for the forest department? None appears for the parties on call.
Your lordship, in this matter,
Nothing is there.
nothing is.
Nothing is there. We'll not go on merits. If he has something, let him come back.
I bear for the respond number
3.
3, your lordship.
None appears for the petitioner. Also, Mr. D. Bora appears, is present for the respondent number 3. There is no one to represent the petition number 1 and 2. Full stop. In view of the above, the matter stands dismissed as not pressed. Nidiba Saida Punoha. I'll not sign it till 4:15. If they come within that, if anybody is there, tell them. If they come within that, we will review this order. No, not press, no, it's a year for non-prosecution. It would be kidding me.
Item 13 and 14.
Which one should I take up, Mr. Roy?
My lord, 4849.
Okay. Okay,
But by this time, my lord, I don't have contact and I think he has retired also.
naturally, he's
My lord,
retired long back.
He's a gross negligent of duty, breach of trust, insubordination, dereliction of duty. Under assessment of the dealers, my lord. Thereafter, I raised some queries and ultimately I abide to it.
and I've sent a demand notice.
Hmm.
If the dealer filed a repetition, got a stayed, so there was a proceeding and ultimately withholding of increment with cumulative effect. But I filed an appeal before the court. Thereafter, it was a delay, so I approached this court. The court by a writ petition at page 57 directed that the representation was not allowed. So the penalty was stayed by the department. Then ultimately, the representation was seen, and my lord, that is page 57. Your lordship got it.
Hmm.
So that was the order passed. And ultimately, my lord, it was stayed, and ultimately the order was passed at page 60, withholding that penalty
What
of
happened, this, Mr. Roy Choudhury,
my lord.
here you had assailed the department proceedings in this page 57 proceeding.
My lord.
In this page 57 proceeding, you
Page
have
50.
assailed what?
There were two orders. Two penalties
Disciplinary
were there.
proceeding orders. Okay.
Two charges, two orders were there.
Hmm.
And ultimately, there were two writ petition.
Hmm.
An order was passed in a single writ.
That's what was creating. This
There
is
there
two
were two
writ-
orders. You will also will find 7/8/2012 and 10/8/2012.
Okay, but only one writ petition is mentioned in the cost title. of
My
the
lord,
law.
that is there. My lord, is one.
Okay.
Here, my lord, in this writ petition, you will also will
So,
find
the writ petition was disposed of only to the extent requiring a reconsideration of the penalty.
my lord,
What was the penalty?
penalty withholding
Two-
of increment
Two increments?
to increment with cumulative effect.
Okay.
Page
So
51.
you are not questioning the findings of the
My
inquiry
lord, what
officer?
I find, my lord, after the penalty, I filed an appeal.
Hmm.
After penalty, I filed an appeal, which was pending during the time that I came for a writ petition.
Hmm.
The appeal is pending or not, I am not aware of, my lord. Can your lordship, taking into consideration the proportionality, my lord, direct the appeal may be disposed of, if not, taking into consideration the proportionality of the penalty. With the cumulative effect, your lordship knows more than me, my lord, it's kind of a major penalty.
Now, what I don't understand is, there was an order. These orders are on record, 7/8/2012.
My lord, 7/8, page 51.
Okay. Withholding of two annual increments without cumulative.
Yes.
And the other one,
Other one, my lord, in another writ petition,
this writ petition,
yes, my lord, this writ.
page,
Page, my lord, I take your lordship.
67.
My lord, 67. With cumulative effect,
Okay. So four penalties, four increments will go.
my lord, for increment.
Or four increments should go.
Two my lord DPs.
Two DPs,
Two orders.
so four increments.
Otherwise. In the meantime, he has retired, but in 2020, he has been promoted.
He has been granted a promotion.
Yes, my lord. Today morning,
That I
I
could
got
not
a
know. No context, no context.
7/1/2020.
That department will know because the client does not contact us, one of that.
Yes, my lord, he has been promoted.
So-
As per the prayer made in his writ petition,
Hmm.
he has been promoted to the post of Assistant Commissioner.
That is why maybe.
Yes,
not
Assistant
contacting.
Commissioner of Taxes, my lord. And thereafter he retired in my lord 21.
When was he promoted?
On 7/1/2020.
I'm retired on.
Retired, my lord, that date I don't have, but it will be
21.
2021. Because he was 52 years at the time of filing of the writ petition in 2013.
So he retired by this time.
Yes.
But there was, but I have challenged the penalty order also. Page 21, your lordship will find.
So now the two penalties have been withheld without
One,
cumulative effect. So
one without, one with.
no, both without.
No, my lord, one is with cumulative.
5, 6, what are these two orders? 5, 6 and 6, 6?
My lord, 5/6 is after the representation was disposed of.
Hmm.
After that order of 57,
Hmm.
my lord, they have page 60, your lordship will find the representation dated.
Hmm.
Prior to that, the penalty was stayed by this department.
Hmm. And 63,
6-3, my lord, because it was taken the approval from the APSC, I think. At page 64, the order supersedes the earlier order passed by the undersigned by such and such and such.
okay. So this is the disposal of the representative and 60 is the penalty.
Correct.
And here it is 2 without cumulative effect. And what about this?
My lord, this is with cumulative effect. No, nothing. Page 90. Page 90. Government decision to impose penalty of withholding 2 increments with cumulative effect.
Okay. Okay. Okay, you argue.
Well, here, may I, my lord, place one, I have received one paragraph comment, there in my record. In WPC, my lord, 4683. The lordship may go to my lord, please, para 21, para 21, 23, 25 and 27.
Para?
Para 21, 23, 25 and 27.
Paragraph comment.
No, reply to the paragraph.
Sorry.
Perhaps the, my lord, the consideration of the appeal has already been done by, my lord, considering the representation submitted by the petitioner. And the fresh penalty order was issued, which is under challenge hearing.
If you do it tonight, no? If you do it tonight, if you do it. Appeal disposed of, my lord, I don't.
Nothing is here. Because this is old. Sometime in 13 this has come. Okay, you satisfied with the proceedings as to why this penalty has to be interfered with.
My lord, because your lordship may turn to now the
We'll go from the charge.
charge. Page 32. The show cause is page 32. May I read it? Page 32, your lordship.
Oh, come in only. Yeah? Yeah, rolling. Yes.
My lord, number one, while you were working such and such, my lord, you assess the dealer such and such under sales tax for total aggregate value of such very carelessly and without applying your mind. And
Okay, fine. This is the charges.
charges.
You denied it.
Denied it.
Then there was an inquiry.
Inquiry.
And
Inquiry.
the
is at
inquiry
page-
report.
My lord, inquiry is at page 48.
Okay. Now one of your grounds in the earlier proceeding was you did not get your inquiry report. Now you have the inquiry report also. So inquiry report proved.
My lord.
Right?
My lord, first of all, I took the plea that, my lord, the freight and others are not included in the assessment and
Those
others.
are on merits.
Merit and ultimately. my
What
lord,
is the denial made to you in the inquiry? What is the deprivation?
Deprivation in the sense, my lord, that because I made the demand notice thereafter.
No, I'm not on that, in the procedure.
Procedure, my lord, I don't find anything. Procedure is accepted that I cannot raise that, my lord. But in one place, I have found it out, my lord, that they have stated that it was not done by me, it was done by somebody else.
So procedure, nothing.
My lord.
Now show me as to whether the allegation leveled against you, held to be proof, has been so arrived at in
Well,
absence of any material Indian.
My lord, only thing is that, my lord, thereafter on merit, if I can place that, my lord, reassessment I have done, I have made a demand notice.
There is that is again questioned by them, saying once you got the notice, you went and did all those things.
My lord,
Right?
Yes.
And my lord, ultimately, the dealer came before the High Court and got a stay order.
That is your subsequent,
subsequent.
and
So,
that you did it in a rash manner
yes,
because only to get over this. That's
Yes.
the allegation.
That
Not
is-
concerned
that
with
is-
the,
That
what
is,
is more.
that is why, my lord, my first consideration is this, because nothing is there as regards the appeal. Appeal, I have filed it out at page 54, your lordship will find, that I have filed an appeal. When, my lord, nothing has been done, if something taking into consideration.
Yes, Mr.
In both the
Okay.
cases.
Say, my lord, as on there, my lord, he has got the relief. My lord,
Everything
there is
is got.
nothing in the pleadings, my lord, I have read.
That's what I was questioning, Mr.
Yes, again, the
Because
You
here,
can show me something.
my lord,
Which is not-
ultimately, he wanted to get a promotion, that is why
That
now I
he has
came to
got.
know, man. I didn't have that knowledge that he got the promotion and everything, my lord. Because he never
Procedure meticulously followed.
meticulously followed that.
Conclusions, if not perverse, we cannot,
My lord, your lordship
interfere.
will not interfere in
will
judicial.
not interfere.
Only that is why I was asking for, if regarding that with cumulative effect, that one, well, some proportionality.
No, for that you will have to show me some error somewhere. Your subsequent events will not be,
My lord, that
Chairman.
cannot take up.
because these material you were also there in the inquiry.
Only thing, my lord, if appeal not dispose of that way, if your lordship can.
At this stage, maybe not.
Yeah.
Call for. Better case next time.
Both the cases.
We'll consider.
Well,
Dismiss.
my lord,
Dismiss, one right?
Chamber.
Chamber orders. You will not get this thing. I can't go and get it. List order, delivery of orders. List this matters again on 7/2/2024 for
Well,
delivery of orders.
well,
Well,
obliged.
Discontinue. Nalagi mo sir.
Item 15.
Yes.
I have submitted written arguments yesterday.
Have you given him a copy?
No.
You have got a copy. Take a copy. You go through that. We'll have it in the second of Mr. Dubey, if you're not otherwise inconvenienced.
No, but we can have now and then.
No. Some things are there. I think you will have to go through that. He has brought
Correct.
materials on record.
At two, then.
Two, or we'll have it on. Sixth. You're here on sixth?
Yes, madam.
Sixth.
Can it be,
Part query with you.
on H, my lord?
Eight,
On
okay,
eight.
part, it'll come up.
Well,
Part. 13 part. List again on 8/2/20. You go through that.
Item 16.
yeah, please, Your Lordship.
Yes, Mr. Chaudhary was to be here
Yes.
yeah, man, today for some health reason he could not come, my lord.
because this is pending for a long time.
My lord, I understand.
Only
Regarding
that-
Pay parity, my lord. Pay
Where is
parity.
Mr. Chaudhary? He was having the records also. Last time the records were there.
Yes, records were there. then.
Ah,
And
he was making a submission. So some reason I think it got
Lordship.
Yes,
In fact, it has been allotted to him, but today he could not come, my lord, for some reason. But can it be Thursday, my lord, day after tomorrow? In that?
Thursday would be problem.
No problem.
We will only can have it on 15th.
Learned advocate, he sought time
Huh.
for taking instruction from the respondent.
We were coming to that
Otherwise,
conclusions.
Yes.
otherwise your lordship has, I mean, almost finished the matter
Matter.
because you have read it
I am,
thoroughly.
my lord, not aware of
No,
the
no,
idea, but.
On the
after-
prayer made on behalf of Mr. B. Chaudhary on health grounds, list this matter again on 15 to 24. He's having some health issues,
Yes, my
so
lord.
let it be on
Pending,
15.
lordship may kindly take note of that.
No. I know it.
two of the
If Mr. Chaudhary for some reason cannot be here, get
I
hold
will
of
follow,
from
I
him
will.
the instructions. Please.
My lord, I have one information.
Yes,
Two of the writ petitioner, they have already expired.
sorry.
So,
When?
also that
When they expire?
a few months back,
Few months, then it's okay.
only expired.
We'll see. Don't worry.
On 15, my lord.
15.
15.
Item 17.
Yes.
Hey, please, your lordship. The petitioner has been praying for provincialization of his service budget.
Hmm.
What's it? Since
Yes, what has happened, Mr. Sharma?
My lord, the last updated the instruction on 9/1/2014 and 2024.
How can you place it before the committee once the SLC has approved it? That's what I wanted you to address.
My lord, as per notification.
A notification cannot go beyond the act. That power under 14 of the SLC, how can you be delegated to some other body? And it's only for that reason that the person's provincialization is not taken to its logical conclusion.
So the power under 14, under 17 Act is an appellate power, my lord.
No, not 14. That power of
Section
the
13.
13 of the SLC.
Now, your lordship, if your lordship will kindly peruse this notification, this joint committee has not been delegated the
No,
power
You
of,
see the notification?
yes, my lord, has seen the notification. This is the committee, my lord, which has been constituted by the government for assistance of the state level committee.
No, here the thing is state level committee has approved and then it went. How can that
Yes,
come?
my lord.
Come to your instructions.
My lord. Subsequently, the joint committee had
The state,
Fine.
1, 2, 3, 4th paragraph. In compliance of High Court order dated so and so, the state had recommended for provincialization of service of so and so
my lord.
as per the proposal receipt. Now, after this,
My lord.
how can you give it? Show me the provision in the act.
My lord, what this joint committee actually does, my
I
lord.
don't want to know
Well,
about it.
Your lordship will kindly allow me.
No, we will not. Anything which is beyond the act.
My lord,
I can understand. SLC has not taken a decision. SLC has not taken a decision. Some inputs is giving you under your internal agreement, you are giving some inputs to some bodies, understood. Here the categorical stand is SLC has approved.
yes. My lord, here the joint committee, if the SLC recommends, this joint committee can only verify the recommendation whether
Why?
But
It,
what
it's not a body constituted under the act.
it cannot take an independent decision.
It is doing that.
But-
It's being rejected because of there
No,
are orders being
but-
passed wherein the cases
So
are
lordship will-
rejected.
Lordship will kindly appreciate, my lord. This joint committee which has been constituted, this committee consists of members, my lord, from finance department, elementary education department, and secondary education department. So that this committee is considered because these committees parameters of looking into is whether the candidates' names are there in the DICE data or not, whether the recommendation.
You
which has come-
disband your SLC.
My
Let
lord,
this comment. You disband your SLC.
No.
I mean,
this committee, my lord, gives a solution to the SLC, my lord.
no. You have not again marked my words. Have you
Hello.
seen the
Yes,
instructions?
the language of this instruction, my lord, it's so.
Then you come to page 123 of that book.
My lord. My lord.
Subsection 11.
The state
Right.
level committee shall have to cause physical verification of all institutions
Inspect
and
all
will
documents.
all inspect all documents, records produced before it and call for such orders, other records and documents as may be required for the purpose of causing verification.
Now, come to the notification you have given
My
me,
lord.
14/9. Same thing. Same thing, but I don't know why nobody is put at this to challenge.
The government is pleased to reconstitute a joint committee for provincialization of services. As mentioned below, to examine the cases for provincialization of the services of the teaching.
We'll
staff.
follow your instructions. We'll say that the committee, state level committee having recommended his case has to be taken to the logical
That-
conclusion.
yes.
And the committee is not a authority under the act. Will dispose of. And I think I have held in that lines. Yes, Mr. Sharma. I think I have passed an order in that line, holding that the committee is a non-entity. I think there is an order.
There is one order.
Can you get me that order?
That are pleased to
Long back.
long back, yes.
Long back means?
Not so back. But
This year,
there your lordship has opined that the committee has exceeded the jurisdiction and
it cannot.
it can.
Can you get hold of?
And the notification, if your lordship will see, the parameters that the committee can examine are this, my lord, this 1, 2,
But
and 3.
see what is being done here.
Here particular maybe in this case, my lord.
No, in every case. Today itself, I got many cases wherein they say, no, because the committee said, now go to the district level and verify. What is the role of the SLC then? Disband it.
Otherwise, the purpose of this forming this committee was to
Assist the SLC.
assist the SLC.
But it's not there anyway. Here after the SLC is given, you are sending it to the committee. And this is not called. This is not accepted.
It is just for the-
Nothing for us.
Yes, yes,
We only know the statute.
yes.
Once the statute says something,
Statute, yes,
we can't
there is
go beyond that.
there is nothing in this.
And see,
Because section 13 is very clear. It is the two-tier committee, one district level
you
scrutinizes.
can have 8 layers, 9 layers, there is no problem. That is your headache. But once you have found yourself in this manner, can you go beyond that?
Yes. Moment the state level committee recommends it.
There shall be one state level scrutiny committee.
Yes.
On the next date fixed, the secretary to the government of Assam, Department of School Education, shall place on record instructions as to why, after the state level scrutiny committee had recommended the case of the petitioner for provincialization, and the matter was submitted to the government for creation of the post involved. The matter was placed before the joint committee. Full stop. The provisions of the Act of 2017. ये पूरा लिख देना ये बुक में page 87 school में 2018 does not contemplate any such committee called the joint committee. The said act only provides for a two-tier consideration, one by the district scrutiny committee and the other by the state level committee, state level scrutiny committee. Full stop. The petitioner's case having been recommended at both the said levels, it is not understood how the government, in violation of the said Act of 2018, could place the case of the petitioner before a joint committee not constituted under the provisions of the Act. Mr. B. Kaushik. Nalai. Full stop. The secretary, while secretary to the government of Assam Department of School Education, while furnishing instructions, shall also consult the revelations made in a instruction submitted by the Director of Secondary Education Assam on 9/1/2024. Full stop. Mr. Kaushik, learned standing counsel for the secretary to the for the Department of School Education shall furnish to the Secretary, Government of Assam's Department of School Education, a copy of the said instruction furnished by the Director of Secondary Education on 1/9/2024 in this matter. List this matter again on 12/2/2024, on which date Mr. Kaushik shall apprise this court as to the instructions received by him on the above issue. Get me that instruction. A copy of the notification dated 14/9/2022 produced by Mr. Kaushik is kept on record and marked as white. Wait, let's see, Mr. What we can do. Obligation.
Supplementary list 58.
Amend it, put it in. Why one? Make 2, 3 more. No problem. But amend it.
Yes,
Not
they
like
could
this.
have taken the assistance of the committee before the SLC takes the decision.
It's not being done. It's like a super committee sitting there. That's what the impression we are getting. How can?
Otherwise, if the joint committee, because the parameters which has been given to them to verify so that the state committee takes a decision in a fair manner.
That verification is already done under the terms of the act by the SLC, or should be done by the SLC. If SLC is incompetent to do it, disband that.
No, SLC delegating it for the purpose of verification could have relied on the
No,
verification
it
done by
has
the
the
joint
power to cause physical verification.
committee. Yes.
It can ask any departmental authority to do that.
No.
Go there, see. And we have also asked the committee, the state level scrutiny committee to do that. But for that purpose, once they give a recommendation, again have that. It's not called for, and you are violating the statute.
That is not correct, because once the state level committee recommends it,
That's the end of the matter.
It is upon the government to either give the approval or not.
Yes.
58 supplementary.
Yes.
May I please, your lordship? Lordship, we can pass over the matter for the time being.
Okay, Mr. Nat. He has got the instructions.
Yes, your lordship.
Whenever he is here, ask him to tell Mr.
Lordship, may kindly take it up at 2.
Okay, fine.
Obliged.
Daily list for motion item 18.
Further instruction was called for.
Yes. Mr. Sutia, Ms. Sutia. Mr. Fukon. Get me the instructions. 5/1. Ms. S. Sutia has placed on record a communication dated 16/10.
Yes.
2023. Record steps taken by regard to provincialization of services of the petitioner pursuant to that.
Achoo, she is here.
Yes, madam, what happened after this?
Item 18.
Now, your DSC has submitted a report. Yes, you don't have the instructions with you.
Some instruction has come, my lord. After some time, my lord.
Okay. Don't give me the old instructions.
Item 19.
Yes.
We'll pick up the matter at 2. I'll get the instruction, my lord.
No, not two. We have other matters fixed that we can't.
That's why there is two different order.
Ah,
That's all.
That's what I wanted you from on
Yes, sir.
11/1.
They have not filed affidavit. I have
No,
not
they-
received any.
Forget the affidavit, madam. We just want that. Why this two treatments?
That.
Because the petitioner, he is also similarly situated with those persons,
Yes,
page
sir.
45, 46, 47. Why? And the order of this court, they have never said, it's a reinstatement. Reinstatement cannot be a fresh appointment. It has to be reinstatement. Back wages will not be paid, different thing altogether. Forget it. But this thing, we'll have it on first or second.
Second, my lord.
Second. And there are few other matters also.
Yes.
Here, in the
There are
list today.
2-3 matters are there. also.
2-3
There's
matters
a-
are there.
Another series is also there, so it's coming on tomorrow.
Tomorrow. Then we'll have this matters tomorrow. Madam, you are here tomorrow.
Let it be on second, madam. In the mean-
Second, we'll have madam.
No,
Second,
on first, not
first,
tomorrow.
first.
Sorry, my lord.
You are here on first,
Let this matter will let it be on second.
second. To try to
Problem.
list this matter. On the prayer of Mr. S. Boran, and standing council BTC, list this matter on 1/2/2024, on which days he shall invariably place on record the instructions as sought for by this court.
Problem.
Item 20.
Look at the speaking order. Page 13 is the direction.
Yes, madam, you have got this?
No, Lordship, I have not.
I'll
You were. I think you'll have to challenge it now.
Yes, Lordship.
Mr. B. Kaushik, in terms of the earlier directions passed by this in the matter, as today punished a copy of an order dated 18/1/2024 issued by the Secretary to the Government of Assam Department of School Education, wherein the consideration in terms of the directions passed by this court-wide order dated 14/6/2023 in WPC number 90 of 2022 was undertaken with regard to the services of the petitioner, and the authority has come to a conclusion that given the nature of the services of the petitioner, his services for regularization cannot be considered. Full stop. The said conclusions as said order dated 18/1/2024 on perusal shows that the same is so issued in compliance with the directions prescribed in this court by the above order, and there is no willful and or deliberate violation of the orders passed by this directions passed by this court. Full stop. In view of the above position, the contempt petition stands closed. However, liberty is reserved to the petitioners to assail the order dated 18/1/24 by way of filing an appropriate application. Huh?
Obliged.
A copy of the order dated 18/1/2024 is kept on record and marked as X.
Obliged.
Obliged, sir.
Item 21.
Made, instruction was called for me. Matter relating to constitution of the school management committee minute.
Yes, Mr. Sisti, where is Mr. Sisti? Sisti,
My lord, he has some personal difficulties today, my lord, he has not come here today.
he has not come to court
Yes,
today.
yes, my lord.
he had undertaken, let's see.
For that matter.
It is submitted that Mr. SMT 60 for some personal inconvenience is not present in the court today. Also, accordingly, a list of SMT 60 Learned Standing Council for the Department of School Education for an account of certain personal inconvenience is not present in the court today. So accordingly, list this matter again on 9/2/2024, on which date the instructions as sought for by this court by order dated 10/1/2024 would be placed on record.
Obliged.
Item 22, order no steps.
Yes, what do you
Withdrawal,
withdraw?
because he has been appointed as a principal or secretary.
Mr. P. Sharma, Learned Counsel for the petitioner submits that the petitioner desires not to press the matter any further. Accordingly, he prays for permission to withdraw the same. Also, prayer accepted. The writ petition stands dismissed on withdrawal. Also, interim order passed if any, shall stand vacated. Most of them.
For admission, item 23.
Yeah, please. Your
Yes. Yes, where are the instructions? Who was supposed to, Mr. Fukan? Where is Mr. Fukan? No, not you, not you. No, A Fukan. You have any instructions, madam?
No, Lordship.
Yes, you.
My lord, I have that my lord, he was terminated in 2006 by the SMC due to unauthorized long absence. So thereafter, my lord, he did not appear. And another, my lord.
Yes. Where is this communication? Order dated 12/1/24.
Can it be taken after some time? I have, I have communicated to the department.
Today.
They have said, no, I have said on 17 January itself, they had given a communication, but that is not sufficient because your lordship wanted specifically.
I want the
regarding-
record.
Exactly, lordship. No,
Who is to bring this record? We'll have it. Patsala.
uh,
12 o'clock. If he starts now, he'll be here by around 3 o'clock.
lordship, the communication, as
Why
per-
have you communicated to the block elementary education officer Bozali this order? If it is so communicated, give me the communication.
my lord, in our WhatsApp communication, we have
Sent.
sent,
Can I record that? He has received it.
to the department.
We'll ask
we
him
have-
to come now.
We have sent it to.
This is not the way an officer can deal with the order of this court.
Lordship, can it be taken after that? I'll be getting instructions actually.
No, I want the records.
My lord.
If you had informed him, why he has not produced the records?
I have
Two
informed
things.
the department, your lordship, the directorate.
Block elementary education officer Bozali, he's within you only.
Yes, under.
Has he received that information?
I will confirm, your lordship.
Confirm and tell me. Confirm and tell me before I rise at 1 o'clock.
Well,
He'll be here at 4 today. We'll sit. We want him here today. You just show me that he has been informed.
Item 24.
Petitioners and councillor informed me that mention it will be coming up on first along with the series. method.
It's about order distributor.
A Budar Board has mentioned it, my wife. she has informed me
Okay, these matters are that
that
um,
series method
similar
is coming
matter.
up first.
List again on when? Second, we'll have it at 2/2/24.
Problem.
Mr. C. Goswami also has two matters, whether he's here, no. Okay, fine. Along with WPC number 5225 of 2016.
Item 26 and 27.
No. 6976 of 2023. Item number 19. Okay? 19 Gumar. Yes.
my lord, the instruction was to be with the government because the governor is supposed to take up the inquiry. We are for the agriculture university. Corresponding to 4.
Then why are you making your submission? Sit down.
No, your lordship wanted to know why not PIL?
No, that is from you, Mr. Das.
From
The government, I wanted to know the agriculture department up to date status with regard to
Yes,
the
yes.
inquiries.
The affidavit that they have filed shows that
the report has been sent to the government. And the
That's what I
government
wanted,
report,
what they have done after that.
yes, yes.
Yes, who is for the agriculture department?
He is not present today, Lordship.
Who?
He is not present today, Lordship.
You are also there.
Last occasion, Lordship,
Tell me why these instructions are not before this court?
Lordship, last occasion, no one from our department is present.
I passed an order.
That's the problem. Only today morning I got.
Okay, give me your respective addresses. I'll send the orders to your mails.
The inquiry was done by the governor, Lordship, it's by the government.
It's with you, madam, the reports.
Then I pray for.
We want to know what you have done. That's all. It's a different question what Mr. Das will submit with regard to this matter, whether being maintainable or not, that's a different thing. But we wanted to know what has happened.
We were unaware of the order, Lordship, because every time the agriculture university.
Yes, Mr. Das.
by
With
paper-
regard to that question about a PI, what do you have to say?
Well, I could not look into it, the matter.
Okay, you
Properly.
take your time.
I-
Because this is something which will benefit me
Yes,
also.
I thought that I will make a study
Hmm.
during the last week, but I could not by now.
No problem. You give me a date. Whenever it's convenient to you.
After 2 weeks, your lordship, when lordship is sitting,
I'll be here till 19th, before 19th, the week before 19th.
week before 19th, no?
Then I'm not here for 2 weeks.
Then in the second week, my lord,
Second week,
15, 16,
15th. 15th, let's put it on 15th.
yes,
15th. You get a holiday on 14th.
yes.
On the prayer made on behalf of the parties, list this matters again on 15/2/2024. That thing,
Yes,
how it should go about,
Yes.
how we should go about.
Hello, the name may be recorded.
I'll get the records, Lordship. Sorry for today.
No, it's okay.
and in
I
the
don't want the
meantime,
records.
your,
I don't want the records. Please don't trouble yourself with the records. I only want an instruction as to what has happened after the reports were submitted. That much only.
Lordship, I'll get the instruction.
yes, that
much
should
only.
come.
If
in
it
the
has
same
been
day.
done, steps have been taken satisfactorily, because what action you will take, it's up to you. He has
Yes.
got nothing to do. But that action if taken, we'll
Yes,
ask
yes.
Mr. Das that we'll close the litigation. That satisfactorily action has been taken. What you take is up to you.
Yes, yes.
We can't
I'll
dictate.
be
neither he will
satisfied with the action taken.
Only the action taken.
Yeah.
I'm only on that.
Yes, Lordship.
And it's something which we wanted Mr. Das to address us with regard as to if a matter like this, whether in the nature of a PI, we can entertain. That's the only issue.
Yes.
It's a different thing. But something has been brought to my notice. I would like to be satisfied. Next.
Published.
May I please the name for respondent?
Yes, heard Mr. Miss
R. Bora, Lordship.
R. Bora for
For the
the
Agriculture
Agriculture Department and also Mr. S.P. Sharma for the
Respondent.
Agriculture University.
Yeah, 456.
and the Agriculture University. But Mr. Das, Senior Advocate, PC Das, Senior Advocate, ऊपर में लिखना for the petitioner. 15.
Obliged, Lordship.
Item 28,
Yes, Miss Day Das Burman. Who is appearing for the government here?
My lord, on the last occasion, Madam D.D. Burman appeared.
Yes, Mr. Yuri, what happened to these instructions from the Superintendent of Police, Sipsagar?
yes, your lordship. Lordship, perhaps our affidavit are also there.
Any finality? Mr. Yuri, any finality with the investigation process?
No, I have gone through this, they are yet to come to a finding, your lordship. Right.
Nothing. Just lying, huh? In terms of the order dated 2012-2023, the B Dury has placed before court the instructions received by him pertaining to the status of the criminal cases involving also the petitions hearing. So it is seen that the investigation of the criminal cases involved have not been concluded, and it has been held that the case is under investigation and FF will be submitted soon. So, accordingly, list this matters again on 18/3/2024, by which date Mr. Dury shall receive the updated status in the matter. Also,
My lord,
the instructions produced by Mr. Dury is returned to him. Also,
my lord has recorded that against the petitioners, my lord. In fact, against us, there is no case, my lord.
there is no case. That's why I said that I wanted a specific thing,
Yes, sir.
but they have been giving us all this
All clumsy,
information.
my lord.
Let's see, let's see.
That may be clarified, my lord. because in the
At this
order-
stage,
My lord.
Mr. A.R. Bhuiyan submits that although it has been held that there is cases pending against the petitioner, till date, they have not been apprised of any such case
My lord.
pending against them.
My lord.
So the investigating officer, while submitting his updated report, shall also take into account the above submission.
My lord.
If he says you are not there, we'll proceed.
Yes, yes. Obliged.
Very good.
Item 29.
My lord, in earlier occasion, lordship repeatedly asked
Yes,
for-
Mr. R. Mujumdar. Where is Mr. R. Mujumdar? Call him. Wait for some time, let him come.
My lord, earlier occasion, same thing was happened.
We'll see. We'll ask the secretary to be here, don't worry. Mr. Kaushik, Mr. R. Mujumdar is around here.
He's there.
If he can come in, he comes in, or we'll have to invite. Those 2-3 days, it has gone now, like this. If he wants to come, he can come before the first half, or we'll ask the director to be, or the secretary to be.
Item 30.
Yes. Mr. Bora, provincialization order.
Exactly not the provincialization order, my lord, it is. Next page, my lord, that is another person.
Hmm?
Another person that is from the list, my lord, he has provincial, he also appointed as additional district. Paragraph 9 of a second.
This page, last page.
Second page.
These are appointment approval.
There's another teacher, my lord. They're not Malati Bepari, my lord.
It's not here.
The next third page is Malati Bepari. Regarding, my lord, this is
No, first page is that letter of yours.
my lord.
Second page is
That is
Approval.
Nabanita Mondal.
Nomanita Mandal.
She was also
Third page also same.
same, my lord. That is Malati Bepari. Additional, that was initial approval, my lord, by the district elementary. division.
Nomanita Mandal is also before us.
My lord, she has
In another
now-
case, I
My
suppose,
lord, she is now appointed.
appointed.
She was also an additional.
I think I was dealing with that matter. Is it disposed of?
My lord, that,
Nomanita Mandal,
my lord,
yes.
in the first page, that is reflected her regarding her. Nabanita Mondal.
Yes, this matter, I think it was before me. What was the order passed? I think it's listed for Nomanita Mandal, delivery of what is the Kanyasini? Delivery of water Kanyasini.
So on second.
Nomanita Mandal. Aji নাই, কেতিয়া আছে এইটো? 5 তাৰিখে আছে। 2 তাৰিখ। Second.
It is on second for delivery.
Yes, I remember. So,
Petitioner is in the same footing, man.
who is senior? Nomanita Mandal,
I am on 96.
90. Malati Bepari,
96.
96.
Hindi teacher.
Nabanita Mandal. ঠিক নবনীতা মন্ডল is the Hindi teacher, my lord.
And you are?
I am an assistant teacher. Malati Bepari, additional teacher, BA. 4296. my lord.
So there is no dispute between you and Nomanita Mandal?
No.
Ase no?
Lord, my friend has instructed me, my lord, that she has already been provincialized. Now she
This lady.
Malati
Malati
Mandal, and my lord,
Where is that order?
that order we do not have, but she has preferred the writ petition for her back wages.
No, I'm not sure. I would have to have
My
that
lord.
instruction.
Yes. My lord, we can find it out. sir.
We'll have this matter on second.
Second.
That matter is also coming up
My lord.
together.
My lord.
The instructions as punished by Mr. P.K. Bora today is kept on records and marked as X. List this matter again on 2/2/2024 for further consideration. You get that it has been stated in the bar that the services of the petitioner has been provincialized during pendency of the present proceeding. Mr. A.R. Bhuiya will place on record copy of the said order of provincialization on the next date fixed.
My lord, of that Malati Mandal, my lord.
No, of your, sorry.
No, my lord,
Yours.
I have not been.
You have not been
No.
provincial. Malati Mandal we have
My
in
lord.
that case.
Lord, may I pray for a copy of the, my lord, provincialization which has been placed? before my
No,
lord?
that order is not here. It's in that other case.
No, my lord, today which.
Here that only instructions are there,
My lord.
but the order is not there.
My lord.
Obliged. It is. Second, on second, that order I fixed for delivery of orders.
My lord.
So this we will also take
Yes,
care.
yes, my lord.
Mr. Goswami,
Obliged.
you need not wait. You are waiting for that PTC matters.
Yes.
It has been fixed on second, other matters. So I'll fix your matters also on second. Right?
Obliged.
So I need not wait. Second, Mr.
37 and 38.
36, 37, 38. 36, 37, 38, individual order motive. List this
36,
matters
Your
again
Lordship,
on
On behalf of P. Nayak, Your Lordship.
that you will see on that. 36, 37, 38 on list this matters again on 2/2/2024.
Deeply obliged.
You need not wait.
Item 31.
Wait, please, Your Lordship. In this matter, though I was selected for the post of assistant professor in statistics, my lord, I have not been appointed.
Yes.
My lord, if my lord comes to the permission granted
The permission, my lord, will find at page 32, my lord.
The granted for the advertisement,
Yes, my lord.
selection done,
Selection done,
matter sent to the director
my lord,
for approval.
for it.
Thereafter, nothing.
Thereafter, nothing. Now they have come up with an affidavit saying that this roster point number 48, against which the post was advertised, that is
Where is
for,
that affidavit?
my lord, affidavit filed by respondent number 3, my lord.
When?
I was served a copy on 21st December, my lord.
Huh? It's not come on record. Affidavit file, koi se second copy court. The same I did not find any affidavit, and there is no noting here. It's not here.
And needs to be brought on record, my lord. Be taken up on record. My lord.
Mr. Das, have you filed that affidavit?
Yes, ma'am.
Mr. S. Das, Leonard, Standing Counsel, Directorate of Higher Education submits that an affidavit on behalf of the said respondent had been filed in the matter on
On my lord, filed in the month of December, my lord, December
a file sometime in the month of December 2023. Also, registry to trace the said affidavit and tag the same along with the records of the present case. Also, list this matter again on, yes, Mr. Nayak, when will you be?
My lord, 15th February, my lord.
15 February, 15 to 2024.
Deeply obliged.
You are not filing any affidavit, Mr.
No, we have already approved it, but what has happened is that he was appointed in roster 48. It should have been 47. Therefore, it was not approved by the department. Actually, there was a erroneously advertised by us. It should have been 47. And it is a reserved post.
Okay, 47 belongs to which category?
OBC. 47 is
And it has been advertised as a
48.
Unreserved.
Unreserved.
unreserved. Next post,
But my lord, 47, it was for the subject of English, my lord. That person has already been appointed from OBC.
you see one action, you don't see this second one. Wholesome view.
No, we have no problem. If he is also appointed, we have
You
no
have
problem.
created the problems. You are the initiator. They are just the approver. Next day, 15. You take your instructions on that. Whether that backlog, which occasions now because of that reserve post, because of this unreserved thing coming in, whether that has been adjusted subsequently. Just have that instruction.
In the same advertisement, my
Same
lord.
advertisement.
Same advertisement, same process. It's an interchange of subjects. Deeply obliged.
Item 32.
Lord,
Have you got it?
last occasion, my lord.
Yes, I wanted you to submit the medical opinions.
My lord.
Why?
Not responded. Just now, my lord, I have received this. Just
It's a
now.
big, huge file. Carrying it daily is a big problem. You should give it to Mr. Monta. Only
Sorry,
that
my
thing.
lord, I have just now received, my lord.
See, these are persons with disability.
My lord.
We must give them something, some importance.
My lord.
And this matter was here for a long time. 9-1, I required you.
My lord.
9-1.
I have gone through the, my lord, just now I have received in the WhatsApp, my lord.
All the opinions.
My lord, I have not gone, just now. Just now I have not gone through.
Mr. Bora,
My
you
lord.
don't have it. No, if you don't get it also, if you don't have it today. But within a week's time, give Mr. Mohanto the medical opinions on basing on which they were rejected. They were rejected, basing on some medical opinion, give it to them. He will take whatever course required
My lord, I'll-
as per his effort.
I'll-
But next time, if you don't have it, I'll ask the people to be here. This is not acceptable.
I'll-
make it clear, my lord? If
I'll make it-
fail to do it, they will have
to appear
in person
On the next date fixed, full stop. Mr. Bora has submitted that the medical opinions as required to be furnished to the petitioner's counsel has not been received by him till date. Full stop. Considering the nature of the matter, issue involved in the present proceedings, Mr. Bora is given a last chance to furnish to the counsel of the petitioner, Ms. N. Begum, the medical opinions basing on which the cases of the petitioners were rejected. Full stop. Within a week, within a period of 7 days, or make it 10 days from today. Full stop. In the event before the next date of listing, such opinions are not furnished to the petitioner. The Director Elementary Education, as well as any other authority involved in the process of selection and in taking decisions basing on the said medical opinion, shall remain present in the court at 2 p.m. List this matter again on
13 man.
We'll give them some time. I've said 10 days, but I'm giving him some more time. 19 one.
Malad,
19-2.
19 case will be listed, but they will have to comply
Within 1 week.
within a 1 week.
I can send it through WhatsApp right now, Malu. WhatsApp I'm getting.
You do it, I'll see it in the next, because he'll also have to require time. But it should be medical opinions.
Malu.
They like you had produced before this court earlier,
Yes.
right? List this matter again on, last one, list this matter again on 19-2-2020. And Mr. Monta, if you feel that after those opinions you have to challenge it, there is order of this court also. You are at liberty to file a fresh.
I'll see to it, Malad.
Let's see, just go
First,
through that.
let us get it.
Get it first, have it in your hands.
Yes.
Bless me.
Indirectly, we have made it. Challenge is made here also.
What is it?
Okay.
Okay.
Item 29.
Mr. R. Mujumdar is a very rare commodity presence, so he's here. We'll proceed. Yes, what is your instructions?
My lord, one matter had come up before yesterday, on 25th also, I'm picking up printout of that review petition. Here, my lord, the honorable court had ordered that we should declare the results and hold the interview and declare the results. Now, those writ petitions, those orders were reviewed. The only effective order was passed in one WPC Nilutpal Bhattacharya case. There's one matter, my lord, Nilutpal Bhattacharya. And there we have filed a review 20 of 2022. I'll take a printout, my lord.
Against which order?
My lord, WPC 4859 of 2020 disposed of on 4/2/2021, where we were required to
Okay.
declare the results.
Okay, 4-5. And following that, the present order
My lord,
on 8/3/2021 was passed. Okay. What happened to that review?
my lord, that review on the last order is it is to be listed again on 12/2/2024, reflecting the name of the Assam Higher Secondary Education Council.
Hmm.
Stand of the government was that
No,
this,
any order, interim order?
my lord, no, there is no interim order, my lord, because on 12/2 it will come up, my lord. What has happened is the Education Department was not heard when the matter was taken up by this honorable court for disposal. Lordship will kindly have the order, my lord, of 4859 of 2020. Lordship will find.
It's extracted in the order dated.
No, my lord, I'm saying that WPC 4859 of 2020
That
disposed of.
order
on
is
4/2/2021.
extracted, 4 to
The
21
first few lines, Lordship will read, who represented, my lord, Lordship will read.
D. Roy, Learned Counsel for the petitioner, T.C. Shutia, Learned Standing Counsel. The person answer, Learned Counsel for, Learned Counsel for respond number 1, 2, 3.
My lord, so then none of them were the respondents for the government of Assam. Government of Assam's specific case before this honorable court, we had prepared the affidavit to file it. We missed it that day. Specific case was that the entire selection process was marred with, my lord, illegalities. In as much as answer scripts were being taken to invigilators for signature 7 days to 10 days later after the examination.
So therefore, we had stopped the entire proceedings.
But Mr.
And that is why the
Sundar,
review, my lord. We
when did you
cannot,
file your reviews?
my lord,
When did you file your review?
my review, yes, I'll just show you. Those review, they were filed. Yes, these reviews were filed 3/4/2021. 30/4/2021 in Nilotpal Bhattacharjee,
34/2021.
2021.
No directions from the court still now.
My lord, it was listed before, now the Honorable Court number 3 on 8/2/2022 onwards, my lord. Orders are there in the website from 8/2/2022 onwards.
It'll be.
And the others, my lord, the other cases which have been quoted, my lord, those reviews, they've been disposed of.
What?
My lord, the orders were modified that if there is no further legal impediment, only then we are supposed to declare the results. During that time, there was already a stay order granted by this Honorable Court on behalf of other petitioners that no result should be declared. That was not placed before the Honorable Court. So because of that, we got those reviews allowed, since there was an impediment.
Yes,
It was a totally confusing situation.
Totally, this is not the correct fact, my lord. Since in earlier occasion, my lord, this is junior assistant, my lord. My lord, in earlier occasion, my lord, the petitioner approached after passing the written examination, my lord. Then, my lord, the computer efficiency test was held. And accordingly, in terms of the direction of this Honorable Court, computer efficiency test was also held, and this petitioner passed, my lord. Only Bhaiba Bhosa was remained, my lord. Meanwhile, my lord, the government passed an order saying that some anomalies were there. And in the meantime, my lord, this council also filed the affidavit. They say that there was no anomalies. And accordingly, my lord, this Honorable Court was in earlier occasion passed an interim order when I challenged the government order, my lord, the communication. That lordship will find at page 16, my lord, the interim order. In other petitions, the government communication were not challenged. But I challenge in the writ petition, my lord, that is at page 17 and 18, 6. The relevant portion 18, my lord. Page,
Okay, no fresh process.
Yes.
This writ petition
Then lordship.
This writ petition is pending.
No, this writ petition has been disposed of in compliance of the earlier order, my lord, that Nilotpal Bhattacharjee case.
Okay, that is what I.
And lordship kindly have a look at
Page 25.
Yes, 27. Lordship kindly have a look at this final order of this Honorable Court. My lord, lastly, as 25, my lord, as agreed by the learned counsel for the parties, these petitions stand disposed of in the terms and conditions as order of 4/2/21 in WPC Soencho, by directing the respondent Assam Higher Secondary Education Council to complete the process of selection to the post of junior assistant as per the advertisement dated Soencho and published on 11/5/18 at the earliest on or before 34/20/21. In view of the final order
You
passed.
come to Mr. Secretary, that last paragraph where it is quoted after hearing the learning council.
Yes.
So-and-so, they is allowed to complete the process. So-and-so is advertised. So-and-so at the earliest, and to declare the results accordingly, thereby completing the recruitment process in accordance with law. If there is no other impediment in doing the same.
Yes, now lordship will find page 30. Page 30, lordship. Page 30, it's a letter from Secretary of a Council, my lord, to the Commissioner Secretary regarding recruitment of 31 posts, 31 numbers of post of junior assistant. So, my lord, this here it is stated, my lord, in inviting a reference to the above.
I've read it.
Yes, and of course, now thereafter lordship will find this for Bhaiba Bhosa notice was issued next page, my lord.
And your names, your roll numbers figure here.
Yes, yes, it was figured, my name. And lordship will see at page 31, lordship, the notice was issued for Bhaiba Bhosa, my lord. Now, in the meantime, my lord, lordship will see 32, page 32. Again, the councillor has issued a letter, my lord, to the commissioner for holding the interview on 24/4/21 and 25/4/21. Lordship has got it.
I have seen
Yes,
it. You
yes.
can come to page 33.
Yes, now Lordship will find at page 33. 20th April 2021.
Yes, Mr. Mozumdar, where is the speaking order?
Yes, there is,
24,
there is.
2021?
There is.
Here, speaking order, my lord, they have, next page, my lord.
It's not there.
It is not there. Speaking order is not there.
Some finding they have enclosed, my lord.
Where?
I'm giving it. Madam.
Here in 33, 34, my lord.
30?
There is
30,
no 34 page.
next to 33, 34, my lord.
34, I don't have that page.
Oh,
Mine is at last is 33.
33, yes, yes.
Yes, 24.
That is exclusively for Mr. Chetri. 34
No,
page.
no. Probably 34, only it was
My lord,
enclosed
The
letter.
speaking order may have sent it by mail, madam.
It will get a copy, ladies.
Some, this,
Where is that page 34? It's not here.
Code 26. Code document. Code 26.dhc.
probably is 9.
So the whole process is now standstill.
Yes. And now, my lord, in my case, my lord, they have reviewed saying that but no such notice was issued to me in the review itself also.
In your
But,
case also,
only-
there is a review.
Only that one line has been stated that there is no
No, no, no,
impediment.
no. In this 8/3/2021 order,
Yes.
there is a review.
Yes.
Oh, you can help me with my-
My lord,
In the
in my
case-
case, my lord, Tikendrojit Saikia 5745.
Just a moment. Where is, in which case does the names of Hemanta, Pegu and Deep Das figure?
This is in annexure 20, my lord. Oh, and page 20, annexure 4, my lord. So, Pegu,
Nilot Paul. Deep Das, yes, Hemanta Pegu, 9.
yes,
So this is WPC 5745.
yes.
Any review filed in 5745?
In 5745, my lord, they have filed a review. Only
pending.
one line has been added.
Mr. It's pending or disposed of?
Dispersion. The review allowed saying.
Give me that order.
Yeah.
Where is that order?
I'm bringing it.
My lord, that order I have collected, my lord, they have. Only in subsequent part, I came to know about the review, my lord.
Yes, it is entering to a select.
The last one line has been added, my lord.
We'll have to wait. The court also holds that your order is not an independent order. It's following 4859/2020.
Yes,
Yes.
that has been marked, my lord, with the that particular order. My lord.
We'll consider.
I.
You get me that, you
Yes.
get me the results of that review.
I will have the entire, may I just pray, Lordship will fix a date. Because the cause list does not reflect, I am not carrying the bunch. I missed it. Lordship will give me a fixed date, I'll have the bunch carried that day. I can give all the orders, the stand of the government also in that particular speaking order I just placed. My lord.
Your placement. I'll go. through.
Lordship will find we have taken down all the illegalities that have occurred.
No, that is. different,
Chairman
but-
himself says illegal.
But the orders of this court is now prima facie important.
Yes, that is important.
It has to be because
So
the
therefore
court
the review.
orders are there that their cases has to be taken to its logical conclusion.
Therefore, the
You have
review, therefore we have taken up that review that our
Review,
stand was
you
not
do
taken
it
into
because
consideration.
the case in the order Mr. Chetri has placed, therein also the reference is to 4859. So let 4859 be
Disposed of,
resolved.
yes. The
and
review
then
be
we will have it.
disposed
Or we can direct that this case be listed along with 4859. Review petition. What is the review petition number?
of. Review petition is 20.
We'll do that
Yeah.
better. Whichever court is considering that same issue,
Yes.
one shot it can be done.
And since, my lord, in the case, my lord,
in that particular review also, we are not aware about all these things, my lord.
No,
Yes.
I will list this matters with the review petition. So that you can
And
have
only
your
everybody will
say.
have a chance. Only Nilutpal Bhattacharya and my case, my lord, difference is this. They filed a writ petition, my lord, seeking direction to conduct the Bhaiva Bosha, my lord. And subsequently, I filed a writ petition where some communication were there. The government said that there was some anomalies. So to
Be
that
that as it may, your case was also disposed of in case of Nila, that
that has been already taken care of, my lord.
No,
But
it says in the review order also, it says by, because we have not taken an independent view, we have followed 4859. Or we will list it independently. That's correct.
and this writ petition is also independent, my lord, otherwise also.
Fine.
This writ petition is also.
Today, when the matter was called up, both Mr. B. Chetri, Lanark Council for the petitioner, as well as Mr. R. Majumdar, Lanark Standing Council, Department of School Education, had placed on record the copy of a speaking order dated 24/2021 and an order dated 25/2/2022 passed in review petition number 25/2022. Also, it is submitted by Mr. R. Majumdar that the review petition filed praying for a review of an order dated
4/2/21.
4/2/2021 passed by this court in 4859/2020 is pending disposal before this court. Full stop. And the matter would be listed on
12th of February.
12th of February. List this matters again on 19/2/2024, on which date Mr. Majumdar shall advise this court with regard to the outcome in the proceedings in the review. Said review petition said in the above noted review petition. 19.
Meanwhile, also, I will file the additional affidavit, my lord, whatever the documents.
You can.
Yes.
Parties are at liberty to bring on additional pleadings,
Yes.
to bring on record materials coming. Parties are at liberty to file pleadings
Ask Papu to
as
bring
may be called for.
certified copy of this petition. Take a certified copy of this petition.
Item 34.
Okay.
Item 33.
33, 34, okay.
Lordship wanted the clarification in respect of the annexer 7. But it's when the schools which were left for provincialization, the schools and the teachers, they again their particulars were sent for re-verification. This is the list of the re-verification. And no communication was received from the government in matter of provincialization of that school.
Yours is a ME school, Mr.
High
Kota.
school, yes.
Huh?
High school.
High school.
No, high school. So there is no compliance of 10-4.
So, no, they can't be under the 2011, I think it's gone.
It's gone.
So now it should be under the 2017 Act. Why is the cases not being considered under the 2017?
2017.
2017 also lost this petitioner.
Their claim in this petition is under the 2011 Act. They possibly has not even applied for under the 2017 Act. Under the 2017 Act, one advertisement was issued.
Yes, have you all applied for consideration under 2017 Act?
No, Lordship, we have approached, Lordship, after background of 2011 Act, Lordship, we have approached under to consider under section under 2017 Act.
Where is that?
That application, Lordship, I have probably not annexed, but they have applied, Lordship, giving Lordship the court fee of.
Why don't you bring that on record?
That can, Lordship, I can instruct.
File a small additional
Lordship.
affidavit, bring those on record, we will dispose it.
If Lordship, they have applied, Lordship, then I can bring on
Bring
record.
it on. And if you have not applied, say that. You have not
Yes,
applied, we will find out a way.
Yes.
Because if your case is otherwise entitled to be considered,
Under 17 Act, Lordship.
these technicalities we will not allow.
Yes. So by next.
Or
week,
of you
Lordship,
can
I will
direct
bring
them to file an application before the director for consideration.
Let him. List this matter again on 9/2/2024 or 12/2/2024, on which date Mr. J. Kalita shall apprise this court as to whether the petitioners had applied for having their cases considered under the provisions of the 2017 Act, 2017 Act.
Yes.
Further orders as may be called for in the matter shall be passed basing on the instructions as may be received in the matter by Mr. J. Kolita. The communications, first of all, Mr. Kaushik had placed on record the instructions received by him from the Director of Secondary Education on dated 29/1/2024. The same are placed on record and marked as X and Y respectively.
May I have a copy of this?
There are two separate communication, one for 34, item number 34, and one for item 30.
XX দুটা X
XX.
কোনটো চাই ল'ব এইটো আপোনাৰ ইয়াতে
A copy also of the same, if permissible.
not required,
Lordship.
nothing there for your interest.
By next week, Lordship, I will bring on record everything.
And if that is there, we will dispose it of.
Lordship.
Same order 34.
Item 35.
May I please, Your Honor?
Hmm.
Lordship, kindly adjourn the matter for today and fix a next date.
Why?
Lordship, my senior is not here.
Hmm?
My senior is unavailable
Why?
because she is in another court.
Another court. Who is your senior?
Nirupama Soikia.
Madam. She was here.
Yes, Lordship.
I think we have fixed the matter today on her insistence. Yes,
Any day
no
next week.
objection. As prayed for by the Learned Council for the petitioner. Learned Council for the petitioner prays for an adjournment in the matter.
Lordship, kindly fix a date.
And
on
the same
5.
is not disputed too by the learned government, learned councils for the respondents. Accordingly, list this matter again after 4 weeks on a date to be fixed by the registry.
Applies.
Yes, yes,
Item 23.
yes,
Look,
yes, yes.
I have spoken to the director just now.
Why do you speak to the director? I want the instructions.
No, Lordship, what has happened is I have given, on 17th, I had given the instructions. What happened, there was a miscommunication. They have given an instruction instead of the record, there was a misunderstanding between the director and the BEO. So I've instructed them to bring the record. My lord, we'll fix it. One of these days, Lordship, we'll get the record also. There was a miscommunication, Lordship. That's why they have sent a parawise by mistake, the BEO. So actually, the record should have been sent. So, and that was the miscommunication was between the directorate and the, so apologies, Lordship, for that. And we'll get the record, Lordship. We'll ensure we'll get it.
Mr.
Wednesday, Lordship.
A. Fukan, Learned Council for the respondents submits that on account of a miscommunication arising in the matter, the records could not be placed before this court in terms of the earlier order dated 12/1/2024. He submits that the records would be produced on the next date. That would be fixed in the matter by this court. So accordingly, list this matter again on 7/2/2024, on which date, if the records as called for is not produced, the Block Elementary Education Officer Bazali Pachala shall remain personally present before this court at 10:30. At 2 p.m.
At 2 p.m.
And you mentioned at 10:30 that you have received the records, so we'll pass orders.
My lord.
Mr. A. Fukan is required to mention this matter at 10:15 as to whether the records have been received by him or not.
My lord.
So as to facilitate this court to pass further orders.
My lord. Deeply obliged.
Timing 18.
My lord, after a recommendation of the DAC, my lord, it is again placed before the joint committee, my lord, for verification, my lord.
Oh. DSC.
My lord,
It was placed before DSC, SLC also.
my lord,
SLC recommended.
my lord.
When I be, Mr. Kaushik, when I place the other matters? That DLC, SLC thing, when I place it, when is it fixed? 12 to. List this matter again on 12 to. Miss S. Chutia shall place on record a written instruction as to the manner in which the case of the petitioner was considered and the dates of such consideration by the various bodies.
Obliged.
12 to.
Item 39.
May I please, your lordship?
Yes, madam.
My lordship, last occasion, the honorable court directed the department to bring instruction on the report
Sometime
submitted by
maybe
the DEO Nongao instruction for the director of elementary education, lordship.
Yes,
Register 5, page number 66.
Yes. 21/7. 10/1.
Lordship. My lord, 10/1/24.
24/2 first opening. 21/7 second innings. Third 10/1. Now today 31. No instruction. Either you or Mr. P.K. Bora.
My lord.
But they are not listening to you. They are not punishing you. Who have you asked for? They are not listening. The authorities.
For the last time, my lord.
You will not be here next time.
Lordship.
You will be missing.
No, my lord.
Yes, that's what is happening. If Mr. Bora is there, you will come. If you are there, Mr. Bora will come. That's the understanding between you both. And this court is taken for a ride. This is not appreciated. On the next date fixed, if the instructions as sought for is not placed on record, the orders requiring the appearance of the authorities of the respondents would be passed. In the event, the Ms. N. Fukon, Learned Counsel for the Standing Counsel to conduct, N. Fukon, Learned Standing Counsel for the respondent submits that she be given 2 weeks' time as a last chance to receive her instructions in the matter, to complete her instructions in the matter. So, list this matter again on 19/2/2024, on which date Ms. Fukun shall invariably place on record the instructions as sought for, failing which further orders as may be required would be passed. See to that.
My lord.
What is the status?
The last para of the judgment, my lord, ultimately, the authority has been given to the board. The matter is, my lord,
while he was appointed, he was appointed as a grade 4 instead of his post, my lord.
Hmm.
In our affidavit, we have said in paragraph 4 that the honorable court by its judgment dated 22/8/2006.
Is there any scope of giving him some benefit here? No.
Well, in fact, I have received the record, well, he retired in 2014.
No. With regard to the
Lordship.
earlier period,
In fact, that was the decision of the board, my lord. There is,
shall not be binding on the board.
yes, my lord. The last para, my lord.
So in that view of the matter, maybe, because that's the only case he has.
That is the only case.
Okay.
Copy kita, sir. Order ka extra piece ka na diba?
It's okay, Mr. Nath. I just wanted to satisfy myself whether there was something in terms of that para 4.
Lordship. Para 4 ka siya ko. 14 or he has been released from service. अच्छा करते हैं इसलिए.
Anything more, Mr. Nath?
Paragraph 4
Hmm.
and मतलब the para 6 मतलब. The petitioner was appointed as Sahayak. Subsequently, departmental examination for grade 3 post was held
Hmm.
on
He did
11
not
12.
participate.
He did not participate.
His only case was because the committee had directed that I should be adjusted where I am working.
Yes, my lord.
That having not been done,
Correct.
so it's bad. And this court, this order which you have placed before me,
Lordship.
had said that it will not binding
It is not binding.
and you have to take in terms of section 15, which you have taken and he has not challenged.
Yes, my lord. And accordingly, the board has decided that he will be appointed as Sahayak. So that
We
is
will
the-
not
that-
pass anything on merits. If
Lordship.
there is something he has, let him come back. We will dismiss it.
Lordship. Now he is not here. Lordship.
Maybe. If there is something, sometime he wakes up, let him come.
Lordship.
We'll see.
Lordship.
But otherwise, there is nothing. Because my only apprehension was the connection I was not getting. The board and the claim. The committee and the claim. Recommendations of the committee and the claim.
Yes, my lord.
Now it is clear.
Lordship.
None appears for the petitioners on call. Also, on the last 2 days also, when the matter was taken up for consideration, none had appeared on behalf of the petitioner.
Retirement to
Mr. D. Nath has appeared in the matter on behalf, is present on the matter on behalf of the respondents. Also, in view of the said position, the petition stands dismissed for non-prosecution. You can keep this back.
my lord. Copy to the lord. I'm not- Daily list item 40.
Opposing.
May I please,
41 AK.
may I please, Lordship, Mr. I Chaudhary leads me in the case.
He is not here.
For some unfortunate reason.
On the prayer of Mr. D. Deka. You want an adjournment?
Yes, Lordship, and also the affidavit has not been filed by the education department in one.
On the prayer of Mr. D. Deka. This matters again. When do you want it?
Any date, Lordship, bearing 6, 12, and 19, he won't be present. Any other date, Lordship, in February.
On 26,
Yes,
True.
Lordship.
2024. Also. In the meanwhile, the respondents are permitted to bring on record their stand by way of filing their respective petitions. No, sorry, affidavits.
What's the matter?
It's with regard to that condonation of age. 51. My Lord Justice Bhuyan's order. These 3 aspects only.
We have disposed of some of the
some of the you have disposed of, they have made a claim. Bring your stand, or if there is nothing, it's a question of law, you can always argue.
There was one.
But the exact intent of that judgment, subject to what you finally would say, may not have been taken into account. Otherwise, that, and one more plea is there, that they had not filed their applications for condonation of.
Once one affidavit has been filed, it was not perhaps totally correct.
Because
it wasn't
that's something which
No, that-
which they will have to, because
They-
may not be correct also, because their specific
No,
contention and the
they have
direction of
filed
this
it.
court is filed.
They had filed it from in transit from direct to the secretary's
That, for
office.
that, they are
That
not,
I'll have to correct. In the affidavit I made it to the stand.
that you will have to correct.
We'll have to correct, yes.
You also keep this point in view, because that's a wrong statement made.
Yes, yes.
probably.
There's also 41 and 41 similar matter. 40 and
21, item 40, 41, same order.
and they may be listed together.
Together, it's all right.
Obliged.
Item 42.
Wait, please, Your Lordship. Your Lordship may kindly peruse on the order passed by this honorable court. Page
Yes.
43, Lordship.
Who is appearing? Mr. U Sharma. 9/1/24 order. We wanted the decision of the state level committee.
Yes.
You have it?
Lordship, they have held an affidavit in which it is annexed, Lordship. Affidavit held on 23 August 2023.
That SLC is annexed.
Lordship.
Page 66.
Lordship, relevant portion page 67, Lordship.
Where is your name? Jorhat.
Lordship, first one.
Omar Ali
67,
Sheikh, okay.
Lordship. Lordship, because of my wrong quoting of my name from Omar to Amor, Lordship. That is the
Okay.
only division.
What did he do after this, Mr.?
Lordship, I am continuing to serve in the school, Lordship. Since 1990, I
No,
am.
your cases have not been provincialized.
No, Lordship. But pursuant to the direction of this honorable court, they ought to have provincialized my service. Lordship,
Yes, Mr. Sharma.
His case has been placed to my lord, joint committee, my lord.
Joint committee.
Yes.
Okay.
Lordship, my name have been recommended twice, Lordship. Two times, I'll show Lordship. In the
This
affidavit
joint
of-
committee thing I'm considering on 12th.
Yes.
Lordship,
this
but
joint
the
consi-
joint committee doesn't exist anywhere in the.
Fine, I got it.
Yes.
I got it. But I have fixed matters on 12th. We'll consider that issue on that day. We'll have a matter on 12th. List this matter again on 12 to 2024. So, Mr. Sharma has, by referring to the affidavit filed in the matter, has contended that in terms of the orders passed by this court, the minutes of the selection, state level selection committee has been brought on record. On perusal of the same, it is seen that the case of the petitioner was recommended for provincialization of his services by the said committee. However, on account of the matter being placed before a committee called the Joint Committee, no further progress in the matter has been made till date. List this matter again on
Lordship, kindly peruse page 69, Lordship. After putting my case in the joint committee, the joint committee also recommended, Lordship. Now
Joint
page 69, may kindly be peruse annexure 3, Lordship, of the affidavit. My name is appeared in the bottom serial number 3, Lordship. Unlike other cases, my case is something different, Lordship.
No, it might have been placed after this, Mr.
Lordship,
It is after this. When it goes to the government, they place it before the
Joint committee.
joint committee. So we'll have it on 12. We'll have it on that. We have asked the councils to apprise us as to how the joint committee can be held to be a body under the act.
Lordship.
This much only.
Obliged.
Item 43.
Yes, Mr. Sharma. Mr. Mozumdar was supposed to place decisions. Yes, Mr. Mozumdar. What is your decisions? So Soma, you have, Dr. Soma, you have anything more to add? In this case, nothing, that much only. Your case is simple. Court remanded back the matter. That period you will have to count. And the order of your subsequent compulsory retirement is prospective. Yes,
And I'm entitled to
that salary. You are entitled to something for that period.
I have an apex court decision also here also.
Please.
I have highlighted.
Yes, Mr. Majumdar.
One of the first order of this court. Page 31 was the effective portion.
The initial order.
Initial order, my lord. Coming back to the submission made by Mr. Svensson as senior counsel for one of the petitioners. The petitioner.
You can skip that paragraph. You can come to the next one.
In view of the decision about necessary to deliberate upon the other grounds urged at the hearing. Consequently, impugned orders of penalty are hereby set aside and post on the matters are remanded back to the disciplinary for a fresh light in the light of the decisions made above. Now, here we were required to give a copy of the inquiry report to the delinquent and he was supposed to give a reply.
Then?
And then we were supposed to take a fresh decision on his statement. ECL versus my lord.
And Mr. Majumdar,
Karunakar.
just have para 33 for a second.
Para, my lord?
33.
33, that 33 I was reading, my lord. Consequently, the impugned orders of penalty dated 31/12/2004 are hereby set aside. Post.
When did you retire, Mr. Dr. Sharma? When did you retire?
2019.
Okay. So that day when we were deliberating on this issue, we were I required raise a query as to what would be the effect of this. Your stand was that he was continued in service only for the purpose of the penalty, determination of the penalty. But the penalty no longer existed after 9/2/2015.
9/2/2000, madam, that is what I will just try to show from the Supreme Court judgments. When a disciplinary proceeding is set aside on the ground of non-furnishing of the inquiry report, what are the rights of the appointing authority and what rights he would have to the pay and salary? If lordship will have paid para 31 for a moment, madam. Para 31 of the judgment, madam, I was reading. Para 31. Or lordship will have paragraph 28. So kindly have paragraph 28. Therefore, from the above, it will be abundantly clear that the acceptance of the report of the inquiry committee preceded issuance of notice to the petitioners along with copies of the inquiry report. This is contrary to the law laid down in Managing Director ECL Supra. As a matter of fact, so and so issued so cause notice. Then, my lord, at para 31, what is required to be done? 1, 2, 3, 4, 5, 6, 7, 8th line from the top of para 30, from the bottom of para 31 starts with the word hearing before the disciplinary authority on remand. However, since more than 10 years have gone by from the date of imposition of penalty, it will be in the interest of justice the petitioners are permitted to fresh representation along with their earlier representations if they so desire before the disciplinary authority on the inquiry report. If such representations are submitted on so and so. Now, this is what we were required to done.
the entire proceeding was set aside only on the ground of the non-furnishing of the inquiry report, and therefore ECIL was referred to. Lordship should kindly have.
Now
the
you show
ECIL
me from the judgment
My lord.
that this matter was remanded back for a fresh proceeding from that stage. Otherwise, if I read para 33 independent,
Only 33 will not
everything
come, my
gone.
lord. Only 33 is not come. Para 26.
Hmm.
Inshallah.
Come on.
Para 27.
Hmm.
Having noticed the legal position as above, we may now revert back to the letters at 51004. A reading of the said letters would show that the findings of the three-member inquiry committee were accepted by the executive.
You are reading para?
27, my lord,
Okay.
I was trying to. Having noticed the legal position as above, we may now revert back to the letters that so and so. A reading of the said letters would show that the findings of the three-member inquiry committee were accepted by the executive committee on its 265th special meeting held on 2804. Having accepted the findings of the inquiry committee, it was then decided to impose the respective penalties on the petitioners. Petitioners were therefore also show cause against the imposition of the proposed penalty, and it was made clear that the absence of the response, the proposed penalty should be imposed without further notice. Therefore, from the above, it would be abundantly clear that the acceptance of the report of the inquiry committee preceded issuance of notice to the petitioners, along with copies of the inquiry report. This is contrary to the law laid down by Managing Director ECIL Supra. What had happened here is, my lord, when we gave them the inquiry report, we said that we are going to impose this punishment, so give us a response. Court said no. That would not be correct. As a matter of fact, the discipline authority of the university issued show cause notice to the petitioners on the proposed penalty, which was not required. Learned Senior Counsel for the university has raised the issue of prejudice. During the hearing, Learned Counsel for the petitioner has pointed out various discrepancies, which according to them had adversely affected the inquiry proceeding. It has been contested that the petitioners had been put to notice prior to taking a decision on the acceptance or otherwise of the inquiry report. Petitioners could have persuaded the authority not to have accepted the report of the inquiry committee. Under such circumstances, it cannot therefore be said that non-furnishing of the inquiry report did not cause prejudice to the petitioners.
Okay, fine.
So
Got it.
therefore, it was the
Next.
inquiry report.
I got it. Next,
Now, Lordship will have the ECIL case, ECIL versus County.
paragraph.
My lord, I am having a printout under the from Supreme today.
What was the initial penalty?
My initial, if I'm not wrong, was removal. We converted it to compulsory return for all the three petitioners. One of them has accepted the same and he has taken the penalty.
Okay.
Lordship will find the
One query, Mr.
Hence,
Just to get the matter in
My
its
lord.
proper perspective. Your order is at page 32.
page
32.
32. That was the earlier one, 32.
32.
Yes. Yes, madam.
Compulsory retirement, right?
We converted to compulsory, but Lordship will find third line from the bottom with effect from 31/12/04.
Okay. Now
This
this
was
was put
challenged.
this was challenged.
This was challenged. Lordship will find the order at page 35. Now, prior to that, if Lordship will kindly have, yes, page 35. Regarding the submission made by senior counsel appearing on the behalf of the represent is directing the authorities to have verification regarding the amount to the petition. Therefore, if the petition is found eligible for receiving any amount, the same shall be paid within 3 months. Then he made this representation. On this representation, we gave him a calculation at page 37. A second writ petition was filed. Another writ petition was filed at page 40. At page 40, Lordship will find, if Lordship comes to page 42, para 5.
Yes.
It is tried that when any penalty is imposed upon a delinquent officer, the same will not have retrospective effect. The order dated 2/11/16 is an order of compulsory retirement from service of Dibrugad University with regard to petitioner giving a retrospective effect. Accordingly, it is held that the penalty imposed upon the petitioner by order dated 2/11/16 shall be prospective in nature. So he will be deemed to have retired on 2/11/16, but the
16.
penalty has not been interfered with.
No need. He has also not. So the query is.
Yes, yes.
In terms of this
Now
further
Lordship will have-
clarification, with this further clarification here, that the 2004 compulsory retirement is brought to 2016.
Very well, my lord.
This period.
I'll try to address, my lord. I'll come to every point. Lordship will have page 45. He made a representation per the order at page 43. Page 42, Lordship will have down below, petition is accordingly directed to make a representation. to
Now you
competent
come here.
authority.
Yes, 45, last, third paragraph,
Now, page 45.
45, third paragraph.
In view of the above,
Hmm.
the university has come to the conclusion that you would not be entitled for back wages between the period from 31/12/4 to 2/11/16.
Hmm.
However, since the honorable court has directed that the order of compulsory retirement would be effective from 2/11/16, you will be deemed to be in service for that period only for grant of notional continuity for purposes of calculating terminal benefits.
That means his salary for that period
From 4 to 16, we are
to
denying.
2/11/2016
Yes,
has been 2004 to 2016
yes,
has been reckoned by you, but you said no pay, no
we will not
wages,
pay you.
but notionally.
Notionally, we
So
will
that period, whole period has been counted.
for the purpose of
Now,
pension.
now your argument that that period will be not counted for anything. It will be continued only for the purpose of the inquiry.
But that is, I will be truthful, my lord. On that day, I had just spoken what had come to my mind.
Hmm.
Let us go by the judgment, so we will not
Okay.
go beyond the law. If he is entitled, we'll give it to him.
So that was
Holding-
not the correct
That
submission.
is not the correct.
Okay,
Let
then-
us,
then
let us.
proceed. ECI, yes.
Now, ECI lordship will find that page I have given.
Hmm.
The paragraph starts in the middle, hence.
Hmm.
Hence, in all cases where the enquiry officer's report is not furnished to the delinquent employee in the disciplinary proceedings, courts and tribunals should cause the copy of the report to be furnished to the aggrieved employee if he has not already secured it before coming to the court, and give the employee an opportunity to show his or her case's prejudice because of the non-supply of report. If after hearing the parties, the court tribunal comes to the conclusion that non-supply of report would have made no difference to the ultimate findings on punishment given, the court tribunal should not interfere with the order of punishment. The court tribunal should not mechanically set aside the order of punishment on the ground that the report was not furnished, as is regrettably being done at present. Court should avoiding resorting to shortcuts. Since it is the court tribunal which apply their judicial mind to the question and give their reasons for setting aside or not setting aside the order of punishment, and not any internal appellate or revisional authority, there would be neither a breach of principle of natural justice nor a denial of reasonable opportunity. It is only if the courts and tribunals find that furnishing of the report would have made a difference to the result of the case that should set aside the order of punishment. Where, after following the above procedure, the courts and tribunals set aside the order of punishment, the management to the proper relief that should be granted is to direct reinstatement of the employee with liberty to the authority. Management to proceed with the inquiry by placing the employee in the suspension and continuing the inquiry from the stage of furnishing him with the report. The question whether the employee would be entitled to the back wages and other benefits from the date of his dismissal to the date of his reinstatement, if ultimately ordered, should invariably be left to be decided by the authority concerned according to law after the culmination of the proceedings and depending on the final outcome. If the employee succeeds in the fresh inquiry and is directly to be reinstated, the authority should be at liberty to decide according to law how it will treat the period from the date of dismissal till the reinstatement and to what benefits, if any, the extent of benefits he will be entitled. The reinstatement made as a result of setting aside of the inquiry for failure to furnish the report should be treated as a reinstatement for the purpose of holding the fresh inquiry from the stage of furnishing of the report and no more. Where such fresh inquiry is held, that will be the correct position in law.
Okay, got it. Got it. Now
So,
let us
setting
come
aside-
back. Let us understand this.
My lord,
structurally,
get it.
that if it is set aside on the ground of non-furnishing of inquiry report, then the man has to be reinstated.
On-
The period from where he was dismissed till that reinstatement, that is up to you.
Totally,
But from the day the order is set aside,
yes.
he is deemed to have been reinstated.
That
Yes, that we'll have to read because it says reinstatement, dismissal to reinstatement.
The last line, again, we will come again. my-
No, last line
Third
will
line,
have to
third
be,
last line.
have to be read in.
The
no, sir.
reinstatement made as a result of setting aside of the inquiry for failure to furnish the report should be treated as a reinstatement.
Fine.
For the purpose of holding the fresh inquiry from the stage of
No
furnishing the report.
problem, Mr.
And
Sundar.
no more.
Fine, but you read the paragraphs ahead, you can't ignore that. The lines ahead.
What is what? I'm coming to all the judgments that I have. My lord, I'm not trying to deny anything. I'm trying to.
No, I'm
have
only
the
asking
correct
you.
position in law.
I'm only asking you. He was dismissed, fine, that period till the order of this court, the day next. We deem him to be reinstated. From that day till you pass that order, he is in service in terms of this. So he has to be paid something
No.
for that period.
that
I'm not
will be
asking I'm not asking you to pay him from the date of dismissal. But after the order of this court, para 33, 2015,
from
till you issued the order in 2016, what would be the status? I'm not asking for you with regard to, I'm dividing it into two. Dismissal till the order,
Let us.
1 day.
I'll address that also. I'll address it. I'll address it. Lordship will.
It's
Appreciate and come to your
interesting.
point.
I have a doubt. That's why I'm
Yes,
asking.
we'll come to it. So that here, from what I have understood is that he will not be entitled, at least this is confirmed that we are at a liberty to see what will happen from the date of dismissal to the date of reinstatement. We say no work, no pay. That is settled, my lord.
Not settled, but for the time being, I want that second part. What
The
is?
second part. Whether he is required to be reinstated. এখন দিবস। How this part of the judgment has been understood by the Honorable Supreme Court. Paragraph 4. madam.
Okay. So what is this?
Now, this lordship will find at paragraph 4 how ECIL has been understood by the Honorable Supreme Court. Lordship will have, Lordship will give me that indulgence. I will also come up with a contrary judgment. 4. We therefore direct the discipline authority to furnish a copy of the inquiry report to the appellant and then permit her to submit her representation and explanation to the same and pass finals thereafter. However, this will not lead to reinstatement or to back wages. Inasmuch as this court has decided in the case of Managing Director ECIL Hyderabad versus Karnataka that there need be no reinstatement or back wages need to be paid when the court directs the principle of natural disaster.
There are contrary judgments.
It will not be.
There are contrary judgments.
I'm placing it, madam. It will be also 2011
What is that? SBI? SBI Patiala.
I'll give a direct statement. Ananta Saha. 2011. No, it is wrong, na? 2011 5 SCC.
This Hiran.
I'll contradict. I'll put all judgments before lordship. Lordship will come to a decision. I am here to assist. Para 48, lordship will find how ECIL has been appreciated. Exactly contrary view. Para 48.
This is what I was telling you the other.
2013 আছে না? 13 condition না? এটা কি কোন 13 condition না?
Mr.
My lord, yes.
Remember last day I told you referring to FRSR This is the one.
Now, I'll come to FIRs also. Now, my lord, usually I stand on that side, therefore I will have to be very fair. I cannot have a judgment this way or that way. It must be a balanced one. 13th one, the option. State two, yes. This way or that way, state two. Para 10 of the subleasing judgment, 2013 1 SCC 390.
Para 10.
Para 10. Having found that the discharge termination is legally unsustainable, we are of the view that the incumbent, namely the appellant, ought to have been provided relief at least to the extent of counting the intervening period for the purposes of terminal benefits. It is true that during the intervening period, the appellant admittedly did not work. In that event, the division bench was justified in disallowing the salary for the said period. However, for the terminal benefits, in view of the categorical conclusion, so and so, terminal benefits, it was supposed to be counted. Now, Lordship will kindly have para.
This is with regard to, I think, that 4 entry, red entry marks
Yes,
just
yes,
before the period of
yes,
retirement.
It's correct.
Date of retirement. Huh.
True. So, Lordship will have para 8. We have to see whether the High Court arrived at a conclusion that the discharge of the petitioner is unsustainable after setting aside the termination was justified in depriving the appellant from any salary for the intervening period, as well as for the purpose of terminal benefits. Now, here, my lord, I find a reading that since she had not worked for the entire period, therefore, denying the salary for the entire period would be sustainable in law.
Okay, fine.
Then,
okay, fine. You
Yes.
got it. Your
Now,
case
FR
is that on the date of dismissal, from the date of dismissal,
yes,
she did not work. Till you pass the order, compulsory time.
yes,
Now, the question is, no issue. From 2004 till 2015, when this court passed that order,
yes,
she could not have worked because that order of termination or dismissal was holding the field.
yes,
Moment it is interfered with,
yes.
show me the law that without reinstating her also, you can consider that representation. Because why I'm saying so, you are extending, although the court interfered with the penalty, you are creating a situation wherein the employee-employer relationship is not coming back.
Yes.
Show me that in such circumstances, even though the court had interfered with the order, the employee-employer relationship was not reinstated. As of para 33.
ECIL is clear now. The reinstatement.
ECIL says reinstatement for that purpose deliberately. And it says from the dismissal till reinstatement. You do whatever you want to do.
Yes.
You do whatever. I'm
so
also,
now,
I'm also.
now Lordship is on the time frame from the date of the order of the Honorable Court till the date the next order is passed. Lordship will kindly have the
1 year.
date of this order.
1 year.
Lordship will have.
And mind you, you have regularized the whole period notionally.
No,
That means,
that is per subject.
that means you are accepting the fact
That is per
that-
subject.
employee-employer relationship, although belatedly, has been brought back.
That is per subject. That is as per subleasing case. That situation is covered by subleasing case.
Subleasing means that
Yes, that rating entry case, where it says that not work, don't pay, but you only compute it for terminal benefits. That she will not be
no,
denied.
that is again, Mr. Counsel, that is again not a situation envisaged here. Termination part. That is not a case wherein,
No, it is
because the
only-
matter was remanded back because of your enquiry report.
No, But,
Subleasing.
but the fact that if a person has not.
I am giving it to you. Date of dismissal till
Oh, no, I'm
for
yet,
the time being.
no, the second part, I'm yet to come, my lord. That is
Second,
where,
come
my
to the
lord,
second part. Forget the first
where
part.
I'm making a mistake. I'm still on the first part.
No, no,
I'm
come to the
coming to the
second.
second part. So it is 9 to 15. It is 9 to 15 and 2/11/16.
Yes.
That part, if Lordship holds that it has to be a deemed reinstatement and will be deemed to be under suspension for the
No,
period and she
we
be
will
entitled-
not do that now. You have not placed him. We will say that he is entitled to the full benefit.
Full benefits will not. Full benefits. Will.
Full benefit
Then ECL.
for that period.
Then ECL has to go.
No, ECL will be there for the initial part.
No, ECL, when it is said, will be placed under suspension.
See, Mr. Muzumdar, reinstatement cannot be in air. Can it be in air? Can it be deemed? It has to occasion. if it had occasioned, you had to take a decision whether you will continue him or you will place him under suspension. Right?
My lord,
It cannot be automatic.
that Hiranmoy judgment that I had given, my lord, it
Okay,
says that the
that is on
requirement
the
of
facts of,
reinstatement is
I'll
not there.
deal with it. That is on the facts of that case. It doesn't lay down any law. It's on the facts of that case. Now satisfy me in this.
On the second part,
One,
the
one
full, whether she'll be entitled to the full part or the. My lord, the latest judgment, my lord, I have some help here. The latest judgment which has come, my lord, is 2022 AI Supreme Court 461. The 461. Paragraph 6.1, 6.2 and 7, my lord. Yeah.
What does it say?
My lord, I'll just have the citation and picking up the.
Now I'm getting my machine.
That case, that day I have,
I think you placed that.
placed the restatement is not.
I think I've read it.
Honorable
What was the ratio there?
Honorable Supreme Court says that, Lordship, if matter is remanded back to otherwise, Lordship, disciplinary proceedings, Lordship, is directed to start at first, Lordship. If person is terminated, well, then, Lordship, it should not be reinstated at the time of discipline, that remanded period, Lordship.
Here the problem is the order of penalty was set aside.
Even then also.
Has the Supreme Court dealt with that
No,
situation?
even that also Honorable Supreme Court says that for direction to the reinstart, FSA Lordship, the disciplinary proceeding, then the person concerned should not be reinstated.
Should not be reinstated.
This is the findings of the Honorable.
At one person citation to. Yeah, no?
2022 SC.
It was slow.
Probably it is Lordship's file, we have supplied it, Lordship's file.
Yeah, Supreme Court 2022, no?
461.
You are relied on this AIR SC, no?
Lordship.
Page 22, no? No message found to be SC. Yes. Naam to person?
Copy দিয়েছে বাবু।
Party name to people inspector of?
Inspector of Panchayat and District Collector Salem. Panchayat and District Collector Salem. Panchayat and District.
22 AIR SC 461.
461.
Huh?
No, 22 color, page 22 color.
No. 2022
2022.
AIR SC 461. Not being shown.
461.
What is the name of the parties?
Inspector of Panchayat and District Collector Salem versus A. Arichandran.
4611. 4611.
4611.
Lordship, we can mail it also, Lordship. The mail, Lordship.
No, 4611 no idea.
Hiranmoy has been referred to here, para 6.1. Hiranmoy. No, no, it is Hiranmoy. It will be safe one.
Direct one.
मुझे petitioner है जरूरत नहीं है जरूरत नहीं है move on.
Supreme given? 2022? Okay, got it. Yes. Next, Mr.
Should I-
Bose.
should I mail
I
it?
got it, I got it. No need.
So in my humble submission, when the matter is remanded back for a fresh condition, a fresh consideration, it is not a case where the reinstatement will be either automatic or it will be always necessary. Since it was only a case, and Lordship will have that Ananta Saha case again. Ananta Saha case. There one paragraph, page 47, para 47, it is settled legal proposition that the result of the fresh inquiry in such a case relates back to the date of termination. The submissions advanced on behalf of the the result of the inquiry in such a fixed situation relates back to the date of.
There is
imposition
another
of
line of
punishment
judgments,
alias 45.
there is another line of judgments
My lord,
of the Supreme Court,
my lord.
wherein it says, if the disciplinary order is interfered with, the show cause goes. Provided the court does not. Darula, Daria.
My lord, we'll also have a recent judgment from court number 27, my lord, it has been reserved, where this was argued that if the entire thing goes and it has
No,
to be.
here
with a
that
fresh-
will not go because there is a
Now-
interdict of the court that from this
Now,
stage.
one final aspect of the matter that I will place before Lordship. Dipali Kundu was a case. Where my lord, it has been held that petitioners, when it is set aside, they are usually and should be entitled to all back wages. Subject to one condition. It must be either pleaded before the authority or before the honorable court. That I remained without an income for the entire period in the absence of the same. There can be no claim for any money.
No,
for the
that
periods
would
to
come in a
start.
situation wherein they are placed under suspension.
No, it was on a case of termination.
So give me the citation.
Dipali Kundu was a case, my lord, again. Lordship, I'm giving my own view.
Can give me don't give me the citation, just give me the citations only.
Dipali
You can give it to him.
It will be,
Mr. Majumdar,
my lord.
you can give it to him.
No, I'm just trying to find out the citation itself. I forget the citation. That is, this case has been cited quite often to say that people are entitled to the,
I got it.
yes,
But there is a,
2013.
okay, fine.
That will be, my lord, the citation will give.
So your case is following ECIL and the other line of cases you have given,
My lord,
that there is no error on your part in not reinstating him during the period after
he has never asked for the.
after the order was set aside by this court
My lord.
and the fresh order was passed by you.
My lord. And Dipali Kundu was similar, that part that they should, this is 2013. 2013 10 SCC 324 is the citation. And the relevant paragraph, my lord, I'll give, where it is necessary for him to say that when a termination order is set aside, it has to be pleaded by them that I did not have an income, I was suffering, my family suffered, whoever suffered. And
What
therefore
was
I'm
the nature of the case before that, before the High Court?
This was dealing only with termination of
No, no,
employees and back.
Termination from where? Government service, industrial tribunal, what?
Industrial tribunal,
Ah,
but this has also,
that the provision is different. 17 or something. ID Act.
no, here
That
it was
last pay has to
Maharashtra,
be given.
Maharashtra employees of private school condition rules. Government.
They were under the ID Act. Termination
No.
consideration under the ID Act.
Writ petition was filed. And tribunal judgments were referred to. IT tribunal, the tribunals, industrial tribunals judgments were referred to. Eight.
Okay. Okay. You just give a small list, only the case numbers, the citations. I don't want the copies. Just give you citations.
Only thing is, madam, perhaps from what I have understood, if the reinstatement is deemed, if the suspension is deemed, then a substantial length perhaps, but for the other period,
That is your thing until and unless we come to a conclusion that she was otherwise entitled. The
perhaps some
court
other-
comes to a conclusion that otherwise, in the facts of that case, she is entitled. There cannot be a hard and fast rule with regard to back wages. That is the main.
Yes.
But
For
in a
every-
given case, if we find, no, not in. What was the allegation against them?
allegation against the lordship will find at page 15. Para 6. I'm sorry.
Okay, yes.
I'm sorry.
What be-
I'm sorry, okay, that is not the one.
It's para 15(6).
No, para 7. At page 17.
Hmm.
In the case of Sri so the following are the charges framed against him, that while you were posted as
Okay,
LPA,
fine.
you became privy to the willful and fraudulent withdrawal of excess payment of rupees 30 lakhs.
Okay, fine. Mr. Sharma, anything more to
The
add?
Lordship will only perhaps notice that at different point of time, he had given up his claim from the termination of service. He just restricted his claim to anything that he was entitled to for the intervening period. He had given up all the claims, he even given the claim for termination also.
Okay.
The prospect is
Mr. Majumdar,
my lord.
that order you took me to, page 45.
Justice Medici want to know. Our order.
Hmm.
Yes, ma'am.
Now, let's see the reasoning source.
With reference to your representation dated, madam, we'll have the representation first, madam.
Forget the representation. We don't
With
want.
reference to a representation dated 6/3/23, this is to inform you that the university has considered the representation in accordance with the directions of the honorable court. Having gone through the records of the following have been noted. You have not rendered service to the university from 31/12/04 and you are not in the service of the university thereafter. The order dated 9/2/15 in WBC so-and-so did not direct your reinstatement in service and the honorable court had remanded the matter back for a fresh decision. Any relationship between you and the university after your removal from service on 31/12/04 and after the disposal of WBC so-and-so existed only for the purpose of holding the fresh inquiry from the stage of furnishing the report and for no other purpose. In your representation, it is 6/3/23, you have not furnished any grounds for consideration of payment of back wages. In view of the above, the university has come to the conclusion that you would not be entitled for back wages. for the
Good
period-
legal advice behind this order.
My lord,
Good legal advice behind this order. Heard Mr. Dr. R. Sharma, running counsel for deputation. Also-
Supreme Court decision.
I'll apply my mind. I'll come back, whichever way. On the next day, I'm clear, we'll pass the orders. Either way.
since I did not have his arguments or I did not have a copy of those judgments, if a copy is given, my lord, perhaps if something else is to be shown, then I can perhaps.
I'll give you the citations, don't worry.
My
You can take the citation. Mr. Sharma will give you the citation. Give him the citation.
Lordship, may I submit 2-3 lines, Your Lordship? In fact, Your Lordship, the charge, whatever the charge was leveled against me, that has been dealt with in the first instance. That has been taken care of by this honorable court. And on the basis of the arguments placed before the honorable court, the order of removal from service was set aside. The moment I'm set aside, my penalty has been set aside. They have also referred to in their letter, Your Lordship, that notionally I am in service. So when notionally I am in service, so therefore I am entitled to the back wages for the entire period, Your Lordship.
That's the problem, Mr. Sharma. We don't have a clear-cut law on that. It depends on case to case. So it's me who has to now arrive at that conclusion.
That is
Whether
right.
your case is covered with the exception. The general rule is now, no work, no pay.
Now that has been dealt with in.
My
in the
only
judgment, Your Lordship.
thing with you is order of this court till the date you were retired on, you were given the penalty of compulsory retirement. This period, a doubt still exists, which I will have to now. He has placed the matter, I'll have to examine. That much only.
Moreover, your
The
lordship,
other period may be, we don't know how it will be, but this period,
referring
I am
to
with
the
you
FIR,
still.
your lordship,
I am with you still.
as your lordship has mentioned, referring to the FIR, sir, your lordship, that may be dealt with by your lordship. And I'll.
There are three options to take your acquiescence here. You have not challenged those things. To dismiss your writ petition. Two, to give you something for that period. Dismissal of the, or setting aside of the removal order till the compulsory retirement. Third, to deal with the matter from 2004 till the order has come in. If it is the third situation, then there are judgments on both ways, giving on the facts. Let me examine. I'll come back. Third, the party settling. Had Dr. Sharma, Majumdar. Third, third, the party settling. List this matter again on 15/2/2024. If I am ready, I'll pass the order on that day. Otherwise, I'll reserve it.
Otherwise, he's now getting all the pensionary benefits. We have
Fine,
calculated. He's
fine,
getting everything.
fine.
There is no hurry on that.
Let him be
on that issue.
satisfied,
On
but
that-
he should not be having that grievance that this court had not answered his grievances. So we will answer them. Either way, I don't know. Either way, we will answer, we'll deal with that. Fine.
Obligation.
Item 44.
Yes, Mr. Swagia.
The
Somebody the other day was opposing you. Yes, yes, Mr. Bora is here. Yes, Mr. Bora.
No, I am not opposing Melody.
Who is opposing?
Other. Other day, Malad, because he was appearing in this case, he was supposed to hear. But today also, he is on election court number, and will, the item number, special bench has been constituted, Malad. He's on election court number one, court number two, Malad.
Yes, yes, Leonard AG had it.
But we'll continue for the
Yes,
entire day.
Yes, Mr. Soikia, you have basically made your arguments.
my lord,
Any decisions?
but in that case, lordship may kindly consider my lord interim prayer. This is the third occasion, my lord, for my lord difficulty.
Interim prayer at this late time,
No, Lordship,
when we are,
no,
when we are completely into the matter to
Lordship,
dispose of the matter.
No, because the hearing could not be held, because your lordship will kindly see the various orders passed. My lord, right from the beginning, it is always for like if the writ petition cannot be disposed of, the interim order will be considered. From the first day onwards, my lord, this has been gone. Now pleadings have been completed. This is the third day. First day for the Indian name of Advocate General, second day on behalf of my friend, and today, my lord, again for the Advocate General. The
Right, he's
person
in
my lord,
court.
who is on the contract.
There was a returnable, there was no interim order passed.
No,
There was-
it was always the observation here, the first order, your lordship will kindly see, my lord, order date 6/7/2023.
But why this observation
Yes, the first is, my
in
lord.
order dated 24/8/23, the interim order passed earlier stands vacated. There was no interim
No,
order.
there-
actually.
there was-
It
there
is
was
not
no
pointed
interim-
out to the court.
But on 6/7/23, the observation is that
Okay, got it.
list the matter on 25/7/23, on which day prayer.
Mr.
for
Swagia,
interim
we
order
will
may-
finally hear the matter. Don't worry. We'll finally close the matter. When can he come? This time, if he is not
Today-
available,
Today is
alternate.
possible, but because it will continue for the entire day.
I'm not today. When?
Any,
But on that day, this
No,
plea we will
all-
not.
This
Or I
is
will-
third
or I will
occasion, my
conduct a
lord,
case, my
after
lord.
the completion of the pleadings, my lord.
You give me a date, firm date.
Let it be on 8th of February, Malad.
You are comfortable with 8th of February?
Thursday.
Huh?
Yes.
List this matter again on 8/2/2024. So, an endeavor would be made, the pleadings in the matter having been completed. Also, an endeavor would be made to dispose of the matter as observed while order dated 11/1/2024. No further adjournment would be granted in the matter.
Only on the ground of advocate matter has been adjourned, had be something.
Fine, we have noted that. Today, next time, we will proceed. Mr. Bora, if for some reason, AG is not,
Then I will.
you will have to.
Supplementary list 59 for admission.
Please, Your Lordship. In this case, Lordship, we have filed an IA seeking leave of this honorable court that because the petitioner is going to retire tomorrow, that is 31/1/2024. And there is an interim order operating dated 11/5/23 at page 21.
You are for whom?
And for the principal and the governing body.
Okay, that date of birth case.
Yes, Lord.
Yes.
Who is the petitioner? Mr. Ganguly, you are a
Yes,
petitioner?
Lord, I am the
Okay,
petitioner.
fine. We'll consider this today.
Lordship, now if I take your lordship to the page 20, this is the admit card submitted by the petitioner.
Hmm.
By.
Oh, forget it. You are a petitioner?
I'm
You
the
start off.
petitioner.
You place it.
Lordship.
Why this
Lord,
last moment the man should be troubled?
Yes.
No.
We will have the entire matter.
Under suspension, and he, after he joined, he has gone through the records and found that his date of birth is lordship,
Okay, okay. You are for the school.
yes, Lord.
Yes.
Okay. Mr. Ganguly, you start off.
My lord, what has happened in this case, my lord, when I entered service, my lord, this was a deficit grant in aid college in 1993, my lord, when I joined service. At that point of time, my lord, there was no provincialization, so I joined the service, my lord, and at that point of time, I have specifically averred that I gave all the documents related to age, educational qualification, etc. My lord. Lord, that statement I have made in paragraph 6 of my writ petition.
Okay,
That
fine.
at the time of joining, I've given all the relevant documents.
Just to cut the matter short,
Lordship.
your case is that you appeared in matriculation, but there was some error in the dates
Yes.
of
yes.
birth recorded given by the school authorities
Yes,
to SEBA.
yes.
So your date of birth came to be recorded as 64.
Yeah, as 64,
So your date of birth should have been 68.
68. And my lord, at the time of joining service, I could not produce the original of the admit card. That's
Admit.
all I have given original. And
Admit card also will reflect 64.
64 only. That is on that.
Now-
There is no dispute.
now.
my lord.
Your brother
Lordship,
thereafter pointed out to you, as per your horoscope,
lordship.
paragraph 5, page
Yes.
5,
Yes,
as per your horoscope,
lordship.
your date of birth should be
Yes.
that.
23rd month.
Then you file an affidavit
Yes,
saying that my date of birth recorded in the records
lordship.
is wrong.
Yes.
Show me the law.
My lord, thereafter.
Show me the law. Only on that point. That is how your date
Yes,
of birth
lord,
came
that
to be
is-
changed.
That is true.
Show me the law.
My lords, on
We have an act to that extent.
the births and deaths. Act.
Show me how it is to be done under that act.
My lord, the affidavit was shown and thereafter, my lord, the birth certificate was attained. in
You
19
tell me whether the provisions of
Yes.
that act was complied with.
Lord, in.
It is not a case of non-registration. Or is it a
Yes.
case of first-time registration? 92,
Yes.
it's a case of first-time
First time
registration.
registration. Yes.
So that was done on the basis of your affidavit.
Yes.
What value we can give to that?
But my lord, the fact of the matter remains that in 1992, the affidavit was shown, then I obtained the birth certificate. That
You have
certificate-
obtained the birth certificate on the basis of that affidavit,
Yes,
which is a self-declaration.
yes.
It's not that you were born in that hospital and that
No,
hospital
hospital I was
records
not born.
that records. Then
And my lord, the.
you show me that law, Mr. Ganguly. You take me out of this, then we will consider the other issues. Just on this,
Lord, in,
the correction of that date of birth. I'm a court of equity.
Lord,
I can go beyond.
no difficulty. my lord.
So I want you to show me from your statements in paragraph 5,
Lordship.
it's only on the basis of an affidavit.
My lord, the,
And I don't understand. I don't understand this working of this. This is the problem here.
yes. My lord, 1993, when I
You come
submitted.
to page 27, or you read the vernacular at page 20.
Plus page 32.
No, 28. Birth certificate.
Yes, ma'am.
Read it.
ইয়াৰ দ্বাৰা সম্পাদিত কৰা হয় যে নিম্নলিখিত তথ্য অসম ৰাজ্যৰ শোণিতপুৰ জিলাৰ
খণ্ড।
খণ্ডৰ some part is eligible ঢেকিয়াজুলি মৌজাৰ অন্তৰ্গত ঢেকিয়াজুলি পঞ্জীয়ন গোটৰ পঞ্জীয়ন মল অভিলেখ কৰা সংগ্ৰহিত কৰা হৈছে।
Hmm.
Now,
So
Three.
This registration was made. If you come to Ponjayana Tariq, come to the right hand side,
Yes, Ponziono Tariq is
27,490.
1992.
Then
Yes. Yes.
what value can we give this to this?
Look, after I submitted this certificate to the authority. Now, my lords, the fact of the matter is that if at that point of time it had been rejected or dismissed.
We are
For
considering.
reason,
No
no,
damage has been caused to anyone.
Lordship,
No damage has been caused to anyone.
no, damage.
64, you will be retiring 31/1/2024.
2024, my lords. If it is on 60, if it goes by 64. Now, my lords, if it had been rejected or pointed out.
What we do is, we are vacating the interim order. We'll hear your matter. If you get it, you get it.
But
You
then,
get back everything.
no, my lords,
But if I tomorrow decide the matter against you,
Lordship.
this period,
Yes.
how will the money be recovered? This is public money.
No, my lords, money, as far as the recovery of money, that can be made subject to the outcome of the writ petition.
No.
Or in that, my lords,
You are not
the fact of the
entitled
matter
because
is lordships
only
have said-
this. And have you changed your date of birth with the SEBA authorities?
No, my lords, because after, my lords, once I entered service in 1993 and my service book, my lords, from 1993 to 2023, my lords, was contained the same, my lords, birth date of
68.
birth. Yes, 68, my lord.
Fine.
My lord, they have corrected it unilaterally after the filing of this writ petition. my lord.
Okay, fine, tell me. Has your admit card in or records of the SEBA corrected to 64?
No, my lords, because after 1993, once I entered service, my lord, there arose no occasion for me, my lords, to correct that, my lords. And
You
between
passed your matriculation in 85.
1983, my lords,
83.
yes, 1983. I joined service in 1993, my lords. And it is not a fact that this document, this birth certificate, is a manufactured or procured document after 1993, my lords.
It's not a manufactured or procured document, but show me, you had the deputy commissioners.
No, that record, my lord, will not be with me,
Then
my lord. That will
where
be
is
with-
your statement to
no,
that?
that record
Your
will be with the
statement,
authority.
it requires, Mr. Ganguly, you know better.
No,
If it is beyond 1 year, it requires the district magistrate's approval.
I bow down.
It's
to
not
what
there
the
on your
lordship is
records.
saying. There's no quarrel with the proposition, my lord. But the fact of the matter is, my lord, that record is for the authority which has issued the certificate to justify, my lord. I, as an individual, my lord, when I go, my lord, I won't have that record.
And the interesting part is,
Lordship.
your contention, you don't have the original of this birth certificate.
No, original, I don't have that. That I've been saying from, and that is the precise reason that the birth certificate was relied upon. Because it was a deficit grant in 8 college.
No, you don't have the original copy of the birth certificate also.
No, original birth certificate I have.
Where is it?
At-
Somewhere I found
No, my
a
lord.
statement of yours that all these documents were lost.
No, my lord. That is not the fact.
Only the admit card was.
Only the admit card, and that is why, my lord, the college authority accepted, my lord. That was, it went up to the DHE. The DHE also confirmed, my lord.
College authorities
between
may have
83
made a mistake.
Yes, my lord, that
Doing that.
mistake is there, but had they rejected at that point of time, my lord, the principle of estoppel would come into play, my lord, because then I could have.
This
gone to
thing,
SEBA.
public money, we can't. We can't. We will not. And if this paragraph 5 of yours was not there, it would have been a different question. also.
No, it's paragraph 5 only says, my lord, that. Yes, my lord, because it,
You affirmed. From where?
no, that is what I have said, my lord. There was no other document at that point of time, my lord, only the horoscope used to be there, my lord.
I'm
Because
sorry,
we-
Mr. Ganguly. I'm sorry. This cannot be entertained.
Look, as far as the record of the Department of Health is concerned, my lord, that record I cannot, as an individual. my
You
lord, I
cannot,
have.
we need not even go into that because they don't have a record. It's you who made that application
Lord.
and you got it.
That is correct, my lord. Wherein lies my lord, where is the fraud or misrepresentation on my part, my lord? I have made an application, they have given a certificate, my lord. If there is any allegation, my lordship will kindly note, they have not even filed a counter affidavit, my lord, in this matter. They come on the last day, my lord, fixing this.
And I will make it clear
Lordship,
that in the event your case is allowed,
lordship.
you will be entitled to full back wages for the period. I'll make it clear in my
No,
order.
that may be done, my lord, because
But you will not be allowed to work in this circumstance. I'm sorry.
no, then I did.
Because this birth certificate has not been obtained in the manner required in the birth and death
So
certificate.
that may have been the case in 1992, my lord, because, but is it my fault, my lord, because the authority has issued me with that certificate?
92, you were around
I was around 24.
24.
Yes.
Yes. Why this awakening in 92? Your brother came back from somewhere in 92.
No, my lord, my brother was very much.
Let's have it for a different day. Ask your client to have a retired life for some time. We will fix this matter.
Lordship will fix it.
We'll fix this matter. I'll vacate the interim order.
Lordship.
This cannot be permitted.
No, that observation may be there, my lord, that if.
We'll make the
matter is
observation.
decided.
Don't worry. Also, the interlocutory application number 222/2004 has been instituted by the applicant. You were respondents number
3 and 4.
public respondents number 3 and 4. Praying for a vacation of the order dated. Where is that order?
Order at page 21, operative portion at page 23, Lord.
Order dated
Sorry.
11/5/2023, right?
Yes, Lordship, 11/5/20.
By which the respondents number 3, by which the applicants were restrained from taking any action in terms of the communication dated 21/11/2022 without leave of. Also, the writ petition was instituted by the petitioner, opposite party number 1, assailing a communication dated 21/11/2022, by which by which the applicant, by which the opposite party, the petitioner, was informed that his date of superannuation will fall on 31/1/2024, basing on the date of his birth, 12/1/1964. Also, the petitioner in the petition has disputed the said contention that his date of birth falls on 12/1/1964 and contends that in terms of the birth certificate as issued to him by the competent authorities in the year 1992, his date of birth is recorded in the official records as 23/5/1968. Also, the petitioner further submits that the date of birth as recorded in his HSLC exam records as 12/1/1964 is not correct and was so done on the basis of erroneous records produced by the school authorities wherein he had studied. Full stop. Today, when the matter was taken up, Mr. Ganguly was required, a query was put by this court to Mr. Ganguly as to how the birth certificate issued to him was so issued by showing the date of his birth to be registered in the official records as 23/8/1968. Also, Mr. Ganguly had fairly submitted that the said certificate was so issued basing on an affidavit filed sworn by the petitioner before the judicial magistrate at Tezpur, affirming his date of birth as 23/5/1968. Also, basing on the said affidavit, the petitioner had got his date of birth registered in 1992, more specifically on 27/4/1992, with the Register of Birth, Deaths and Birth, Dhekiajuli, District Sonitpur. Also, on a further query put as to whether the said registration was done in terms of the provisions as contained in the what do you call that? Indian deaths and
Register births and deaths.
Register births and deaths.
Register of births.
no, the act
Births and deaths registration.
as per the act governing the field concerning such registrations. Also, Mr. Ganguly could not place on record any such material towards affirming that the registration as made of his date of birth in the register of births and deaths available in the office of the Public Health Department, Tekiajuli, Sonitpur, was so made by following the prescriptions of the act in question. Full stop. The other public document which is available on record is the matriculation certificate of the matriculation examination records of the petitioner, wherein the date of birth as recorded works out to 12/1/1964, and that is the date of birth now reckoned by the school authorities for the purpose of determining the age of superannuation of the petitioner. Date of superannuation of the petitioner. Full stop. In the set view of the matter, and there being no clarity with regard to the manner in which the delayed birth registration of the petitioner was accepted and the certificate available on records at Annexure 4 of the to the petition was issued, this court is of the view that the interim directions passed in the matter requiring the respondent authorities not to act on the communication dated 21/11/2022 requires to be modified, and the petitioner and the respondents be permitted to release the petitioner from his services on reaching the age of his superannuation as per the recording made by them, as per the determination of the date of birth made by them as 12/1/1964. Also, basing on the matriculation certificates, HSLC certificates. Also, accordingly, the order dated 11/5/2023 stands modified, and the petitioner shall be deemed to have superannuated from his services from 31/1/2024. Full stop. However, with the above observations, the writ petition stands, the IA stands disposed of. Full stop. However, the disposal of the IA and the retirement of the petitioner on 31/1/2024 would be subject to further orders on consideration that would be passed by this court in WPC number 1902/2023. Also, in the event the petitioner is found to be eligible to rely upon the birth certificate issued in his case and the date of birth, that is 12/1/1968, right? No, 23/5/1968 is required to be reckoned. It is open to the petitioner to pray before this court at that stage for releasing to him the areas of pay that would have accrued to him in the event he had continued in his services. Also, however, such consideration would be made in the proceedings, in the proceedings in WPC number 1902 of 2023 after the respondents bring on record their respective stands by way of filing affidavits. The respondents are directed to the respondents in view of the nature of in view of the issue arising in the present proceedings are directed to file their respective affidavits within a period of 4 weeks from today. Also, list this matter again after 4 weeks. List this matter again on 18/3/2024. Also, the respondents must bring on record their respective stands on or before 18/3/2024, and thereafter further consideration of the issues arising in the matter shall be taken up. It's nothing, because that does not give a confidence. That registration, you go through there are decisions of this court also. It cannot be. Because I have to deem it to be a public document. And if it is a public document, I'm bound to follow that. Now there is a conflict between the matriculation and the birth certificate, right? If that be so, then I will have to examine. Because matriculation, nobody has questioned.
Yes, ma'am.
This, when there is a question, I'll have to see, I'll have to go to the background.
Lordship.
If you can take this matter up on appeal and show me, get an order that is not required, I'll be the happiest.
The difficulty is, my lord, the documents, the record would be with the department if any. After
No,
30 years, my lord,
no,
very, very
no,
difficult.
no. That record was not there. You made that registration on your own.
Yes, that I did, my lord.
But if you have to do it,
Lordship.
it requires it's not that you cannot register,
Lordship.
but that has to be by a permission from the deputy district magistrate. And it's clearly absent. I have got cases here
Lordship.
wherein it has been written subsequently that from the records of so-and-so hospital, this person is born here on so-and-so date. But in the writ petition, there is a statement that the mother gave birth to the child in the house.
Yes.
And
moreover, there is
a verification by the Seva also, Lordship, regarding the age.
That we are not, I'm not disputing that SEBA document at all. Anyway,
Public money after all, Mr.
Lordship.
Let it be. If you get it, you get it.
Lordship.
If that query value.
Orders, item 45 to 47.
Silent.
Wait, please, Your Lordship. Lordship, in this matters, will file IA for implement of the new incumbents, Lordship. 2 weeks time. may be
On the
granted.
prayer made by your name,
MR Chaudhary.
Emma Chaudhary, on behalf of Mr. Ayat Soikia, list this matters again after 4 weeks on a date to be fixed by the registrar.
Obliged,
On
Lordship.
that matters, you make this prayers, can't help it. You can proceed. Proceed.
Item 48 and 49.
Yeah, please, Your Lordship. Kindly finish your Lordship order, 4th of January.
Yes.
4th of January order.
No. Yes.
It's lying in the finance department.
Yes, Mr.
Lordship, if I may,
Huh?
Lordship, file for creation of supernumerary post has been sent on 25th of January of this year, my lords. Now we have to process it, my lords.
Then you will send it back again.
No, Lordship.
Actually, there'll be 100 queries. You'll be sending
No,
back. What
we have-
will happen to the order of this
No,
court?
Lordship, we have already returned. This is after this proposal has been sent after the queries have been raised, my lords. So Lordship, right now the budget.
You give me the updated status by
Lordship,
9th.
Lordship, I've been, the department has asked for 3 months time.
No.
Not-
We'll not give you.
No, Lordship may just grant us 3 weeks time, Lordship.
No,
the
no.
budget session is also going on.
We don't know. Our orders are waiting for
Lordship,
compliance.
Lordship will note, we have received.
19.
19, man.
Lordship, there was, and it was filed on 22nd of 20, after 3 years, my lord. They had to.
No, it's a
that-
continuous course of action.
That we are not going into, my lord, because after, it's a
On the
19
prayer
order,
made by Mr. A. Chalial and Standing Council,
Finance Department.
Finance Department, list this matters again
Lordship,
on
3 weeks date time may be granted. Lordship, we will expedite the.
26 to 2024, by which date the Finance Department shall place on record the status of the proposals pending before them towards release of the salaries as directed by salaries of the petitioner as directed by this court.
Obliged, Lordship.
It took here, contempt case,
But same,
same.
well,
That's same order. You pass an order in 96, this you say it will be tagged with this. 39 will be tagged with 96.
Oh, obliged, Lordship.
Mr. Sonia, please use your good order.
Lordship.
Item 50.
Yes, Mr. Day.
My lord, kindly see the last order.
My lord, here we have complied.
10/1/24, my lord.
Compliant.
Compliant.
Oh, very good. See how fast they.
My lord, I have no information, my lord, regarding compliance.
What is the direction?
Pass a speaking order, my lord.
Page 17, my lord. Pass speaking order in accordance with the law within a period of
Okay.
45.
They have passed the speaking order. And the stand is that there were excess teachers available in the list. So tampered list cannot be considered as genuinely, and the claims of the petitioner be considered thus rejected.
My lord, let them file an affidavit.
No,
This
no,
copy
They'll,
complies
they'll
order
give
or-
you, they'll give you a copy. Mister,
I'll-
as I am behind them, once they have taken a stand in
lord.
compliance with the directions of this court, I'll have to accept that. Or you'll have to show me there is deliberate and deliberate violation. It cannot be. The directions are very clear. Only consider your case.
My lord, they have to communicate the order, my lord. They have not communicated
That
the
Mr.
order.
P.K. Bora will do it within half an hour.
I'll.
He'll give it, don't worry.
My lord.
I'll provide for that. Also, Mr. P.K. Bora, in terms of the directions passed by this court in the earlier orders, has produced before this court an order dated 22/9/2023, issued by the Secretary to the Government of Assam, Department of School Education, whereby the claim of the petitioners were on consideration were rejected. Also, I have perused the order dated 22/9/2023, and I find that the same is in compliance with the directions passed by this court wide order dated 27/7/2022 in WPC number 1129/2020. Also, there being no willful and or deliberate violations of the directions passed by this court, this contempt petition stands closed. However, liberty is reserved to the petitioners to assay the order dated 22/9/2023 before the appropriate forum. Before the appropriate forum in accordance with law. A copy of the order dated 22/9/2023 along with its enclosures are kept on record and marked as X.
My lord.
Immediately.
I'll.
Or should I make a,
I'll.
I'll give it to you.
My lord.
Oblige.
Item 51.
Hello, on behalf of Mr. Chisti, my lord, today. He has
He is
taken
having
someone
some
in the
problem.
hospital. My lord, there are instructions which are available, but I am not very conversant.
No
with
need,
them.
no need.
Can it be
We'll
on
have this
some other day? We have the instructions otherwise.
Mr. He is not keeping well. From morning onwards, I'm hearing that. Let it be on. On a prayer made on behalf of Mrs. Sisti, the counsel for the respondents, who is said to be indisposed, comma, list this matter again on 12/2/2024 for further consideration.
Item 52.
Complete also. এইকেইটা থাকক, মধ্যেই। এইকেইটা পাছত পুনি থাকিম তাৰ। Yes, madam, what is your instruction?
Your Lordship, I would like to place it. Along with your Lordship relevant documents received from the DEEO, your Lordship, one lady.
You are a,
I am for contemner, your Lordship, 2.
yes,
Suranjana Senapati, your Lordship.
you are aggrieved by, you're a stipend
So
teacher.
I'm appearing on behalf of my senior, Mr. J. Abedin. He had to leave early today because he got some medical urgency today. Sir. The Lordship may adjourn the matter for the day.
List this matters again after 2 weeks on a date to be fixed by the registrar.
Deeply obliged.
Item 56.
You take back your instructions.
Yes, sir.
Yes,
No, my lord, I have obtained instruction, my lord.
yes.
As per norms of the NIOS, my lord. Application for correction, my lord, is required to be submitted within 30 days, my lord. And the annexure which they have annexed in this, the application of the letter of the principal, my lord, they have never received any letter from the authority, my lord. And even I have checked the petition, my lord. There is no endorsement in this letter also, my lord. May I produce the?
You
instruction?
forget their case, forget their case. Forget it. You have filed an affidavit here.
No, my lord.
Therein you said that the school authorities had lately submitted to you
No,
the
no,
marks. Yes,
no, my lord, I have stated, my lord.
just come to that.
Page 28, para 6, my lord. Is, respondent number 3 never received any letter 5/4/22 as annexed in the writ petition.
Come to page 30. So the study center is yours. Under your control.
My lord.
What steps have you taken against them for depriving the petitioner? Forget the petition, let the petitioner go now.
Now, my,
What steps have you taken? Why the marks were not uploaded in time?
and now, my lord, I have to produce.
Forget this, you tell me orally.
And now, my lord, the thing is that lordship for, as per their own, my lord, norms, my lord.
Is the school the personal property of the petitioner or your
No, no, my
center?
lord. Learner is required to approach the authority within 30 days from the declaration of the result, my lord.
Okay.
My lord, that norms. I
Where
have-
is your, that stand in
My
the,
lord, I have, just I have furnished the.
when did
instructions.
he approach?
No, my lord, there is verbal statement is that on several occasions she has approached. There is no document as such, my lord. And my instruction, my lord, kindly have a look the norms, my lord. I've marked,
These exams are of 19, Mr.
My lord.
Huh?
Exams, final exam was held on, my lord, in the month of January 2020.
2020.
And result declared on 9th of March 2021.
Okay, 9th of March 2020. Show me what you did after that.
My lord, except my lord statement, I have nothing to
Then-
show.
then-
Document, my
then-
lord.
then-
My, as per instruction, I am fairly submitting after declaration of result.
This
Lord,
is nothing but,
She immediately approached the principal. And principal assured, my lord, that some technical errors have been occurred. Though you have appeared, your marks, my lord, kindly see page 25, my lord. The principal has, my lord, given the marks also, the practical marks which I have obtained. And these marks are of first year examination, my lord. And she was unaware that this marks was not uploaded by the college authority. And when she approached the principal said this will be done by the regional manager. And then she rushed to the regional manager,
just
regional
a,
director's
just a,
office.
just a one, Mansur, just a one. Okay,
Now-
where is that document from the principal?
My lord, page 24.
Okay, take me through your mark sheets once.
My lord,
Page 13.
page 30.
So where is practical here?
Here, my lord,
First year?
first year, SBA 5, my lord, in the right hand column, my lord,
Hmm.
511 and 512. Out of 100 marks obtained, my lord.
Where?
Page 25, my lord. This is
Page-
type copy, my lord. Vernacular is last page, my lord.
24, 25.
26 is the vernacular one.
25, vernacular.
This-
No, I'm not on that. These are your mark sheets. Where is your mark sheet with regard to that examination which you got?
Yes, that mark sheet, my lord, page 21. Page 21,
Okay. Absent.
absent.
So this mark sheet was issued when? uploaded?
My lord, when the result was declared on 3rd of March,
Third,
2020.
2020.
It-
Okay, okay.
It was published.
Now show
on
me
the-
something.
It is published on the website.
Okay. Now this is Principal Hills Degree College, Haflong, Dima Hasab, right?
Lordship,
That is the study center.
my lord.
Okay.
And principal is the nodal officer.
Officer, you do one thing. You file applications or cases for damages against you. 2 years, nothing done. What will these people do?
It is the
You
principal.
tell me what to do.
Yes, my lord.
What is the now, one other thing.
It is the.
What is the sanctity of this now? This marks, what sanctity does it have? How can we now say that that is the marks you scored?
My lord, it is the principal and the NIOS, my lord. I am the victim, my lord. Records are there, my lord. They can evaluate the records, my lord.
Can something be done?
My lord, only thing is that this 4.11, my lord.
Hmm.
Yeah, Lordship, I have already put it before your lordship.
Hmm.
Page 4, my lord.
Hmm.
Procedure for correction of result of public examination on demand. In case of any discrepancy of result in the result of public or so and so, the learner may apply for correction to the regional
30 days.
director within 30 days, my lord.
My lord, in this
And
case.
there is no request for correction in the result will be entertained thereafter. The pro forma for application for correction in the record is available on NIOS website under the student information zone.
Okay.
Now
My
the
lord,
principal
they are
is
helpless,
party,
my
my lord. He has received the notice of this court. But in spite of that, he has not appeared, my lord.
Let's see. But we can't help you now. Because if I direct that these marks have to be treated as your practical marks, I'll have to return a finding that these are actually your practical marks.
Now,
They'll not admit to that because they don't know.
my lord,
And they have
can-
not received that till now. That's
Yes.
your case. Laha.
My lord, the papers, my lord, the original papers is with the principal, my lord.
We'll
They
see.
can
We'll see.
evaluate,
We'll
my
see.
lord, all these
We'll see.
things,
We'll
my
see.
lord.
We'll see. We'll see. We tried our best to get you some relief, but can't help it now. Mr. J. Laskar, Learned Counsel, appearing for the response number 3 in terms of the earlier order of this court dated 24/1/2024, has submitted written instructions received by him from the authorities of National Institute of Open Schooling. So, the result of the said written instruction shows that in the event there is any discrepancies in the marks allotted in an examination process, in the marks of, in the results of the examination, has to apply within a period of 30 days to the regional director of his/her region. So, it is also provided, it is also stated that no request for correction in such results will be entertained thereafter. It is the stand of the authorities that the petitioner, neither the petitioner nor the authorities of the study center, wherein the petitioner had pursued the course in question and approached the authorities of NIOS within the time frame prescribed. Full stop. The examination results were declared sometime in January,
March 2020.
March 2020, and thereafter, on perusal of the writ petition, there is no material brought on record to demonstrate that either the petitioner or the authorities of the study center had approached the authorities of NIOS for rectification of the purported error existing in the results of the petition. So, in that view of the matter, this court is not in a position at this stage to hold that the marks as reflected in annexure 6 of the writ petition purportedly declared by the principal of the study center wherein the petitioner had pursued the course is actually the marks scored by the petitioner. Accordingly, no interim direction can be passed in the matter at this juncture. Full stop. The respondent number 3 the respond number 4 shall, that's a principal Hills Degree College Road, the Hills Degree College, Dima Hassan. Hills Degree College, Aflong, Dima Hassan, shall, within the next date fixed, file his, bring his stand on record by way of filing an affidavit. Also, in the event no affidavit is passed, filed before the next date fixed, this court would consider passing further orders adverse to the respondent number 4. Also, the petitioner is to bring this order to the notice of the respondent number 4 by downloading a copy of this order from the website of this High Court. Also, list this matter again on 16/2/2024. You give that, let's see. Last 3 days I have been
My lord, he is the
trying
best
for
per-
you, but
Now he is the best person, my lord, who can say.
yes,
Yeah.
let him
But,
come, we will
my
see how
turn
he.
goes, my lord, my turn goes for
Can't
application.
help it.
Obliged,
I can't blame them because they don't have any material.
obliged.
Item 57.
Please the launch.
Yes,
My lord, we are seeking an interim order protecting the interest of the petitioner in the form of reserving the number of posts equal to the number of the petitioners, or to allow them to participate, to accept their applications, to participate in the selection process.
nobody is. Who is there for the respondents?
In the state government, in the education department.
Mr.
Well, what happened here? These petitioners,
Hmm.
they have been working as Shiksha Sarati, Shiksha.
But Mr.
Commis-
Mr. Monto,
Yes,
that right you establish in your writ petition.
Sorry?
That right of yours as a Shiksha authority to summon, you are also given an opportunity to appear in the TET. There was a
Well,
special
that
TET
is-
for you.
well, we have stated
Oh.
that there was a special test
Huh.
conducted,
Huh.
they could not qualify there.
Then
So therefore, they
we will not,
qualified. No,
on
well,
your prayer, we will not interfere with the,
No, no, well, the question
this we will
is,
not do.
no, that may not prejudice the case. Like,
You have an independent claim of yours as built
Well,
up in the writ petition, go proceed with that.
subject to fulfilling other conditions. If I can qualify subsequently, that will do. I have qualified. That I have qualified, not in that special test, but subsequently held normal test.
Then what is the bar in your
Now,
applying?
now, my lord, since we have been working also, there is no special test.
There
there
is
have been some
there is
special
no provision,
consideration.
Mr. Monto, in the
And
rules.
we are overaged. Some
For
of
that,
them are
you
overaged.
prefer an application before the authorities.
That only, my lord, when this honorable court will allow us to, unless the system.
No, no, no.
System
That
does not
we are
accept
not
it.
coming in.
System does not accept it, my application.
It will not accept still.
That is
Even if
why.
I allow you, it will
That
not accept.
My lord, that is why we came previously. Now this, the advertisement has come.
Huh.
We came earlier.
I
We have
know.
not responded to it. Now, what is the fate of these people?
No, no, no. In the writ petition, it is different.
Kindly see, my lord. We are paying for, similarly now we are asking.
These prayers are there. This will be taken care of
Yes.
in the
Now,
writ petition.
now, my lord, if these posts are all filled up, how their interest will be protected? To that extent only.
Because Mr. Monto,
My lord,
you are representing in this proceedings around 94.
yes.
But how can I only remit this order to 94? There are enough Shiksha authorities in the
My
field.
lord, at least those who are before this honorable
No,
court.
no, no. We cannot,
Those who are before this honorable court.
because as a class, I'll have to consider
My
you.
lord, unless people come seeking something, why this court will?
Tomorrow
Accept it.
morning,
Well, that
Mr.
is
Monto, tomorrow morning, applications would be there before this court and that selection process will
Well,
become a nullity.
No, no.
Yes, Ms. Das, what do you say?
That cannot be.
Have no submissions.
Your lordship, I'm appearing for SSA, your lordship.
Ah.
We need 2 weeks' time to file our
No,
application.
no. What about his interim pay?
Lordship will be pleased to say now that at least their interest will be protected, subject to final result of this honorable court. I am not asking for an appointment right now. But let us go through the
Also,
process.
Likha.
They may.
Mr. K.K. Monta Leonard, Senior Counsel representing the applicants, assisted by Ms. M. Bagum. Also heard Ms. P. Das, Leonard Counsel, appearing on behalf of the SSA authorities.
Yes, sir.
Also, the interlocutory application has been filed by the applicants petitioners who were appointed as Siksha Sarathis under the Siksha Sarathi scheme of Sarva Siksha Abhijan Mission. Also, the petitioners claim that the respondent authorities have now issued an advertisement dated 26/12/2023, and given the criteria spelled out therein, they are not in a position to apply against the said advertisement.
Because
Also.
of the age factor and
Also.
other related issues.
Also, in view of the fact that the petitioners do not satisfy the eligibility criteria and nothing has been brought on record to demonstrate that the petitioners had approached the authorities in pursuance to issuance of the said advertisement for having their cases, having their overages condoned, I am not in a position as on date to direct the petitioners to be permitted to participate in the said selection process. Also, the petitioners in the writ petition have prayed for formulation of a scheme for giving them special consideration for recruitment as primary school teachers by giving them weightage for the work done by Siksha Karmi as Siksha Sarathis,
Siksha sir, Siksha volunteers.
Siksha Karmi and education volunteers.
Education volunteers.
Also, the said issue would be determined in the writ petition, and in the event the court accepts the prayers as made by the petitioners in the writ petition, the respondents would be bound to provide avenues to the petitioners for a regular engagement. However, such an issue cannot be decided in the IA, and the same will be decided in the writ petition as and when the matter is taken up for final consideration. Also, in that view of the matter, this court.
Otherwise, my lord, Lordship may say those who are eligible to apply and get consideration, it is open for them.
In view of the above position, this interlocutory application, the prayer made in the interlocutory application cannot be accepted and it is rejected. Also, however, it is clarified that in the event any of the applicants fulfill the eligibility criteria as spelled out in the advertisement dated 26/12/2023, their cases shall be considered, fulfill the conditions, eligibility criteria as set out in the advertisement dated 26/12/2023, apply in response to the said advertisement.
Two
Their
advertisements
cases
are there, my lord.
shall be considered on their own merits. Also,
My lord, those who have just crossed the age bar, they may make an application.
well, that Mr. Monta, you cannot come and ask for that on the last day,
No,
because you will still not be able to apply because the government will not condone it.
that is why we are asking.
I know.
Unless we apply.
You still have one day. You still have one day. Tomorrow is a holiday. You still have.
Kindly see, my lord, my position. If I can apply with the application, It is for them. to
No,
consider
it
not
cannot
to
be
consider.
because you can't apply. This is not online. This is online. You can't apply
Yes.
offline.
I cannot apply online. By virtue of this court's order only I can apply. Otherwise not.
No, no, no.
And
Whether it's permissible,
thereafter,
Mr. Fugan.
subjective consideration will be made by them. Subjective consideration, my lord, I am not asking.
How
them
old
to
are you?
allow me.
Not very much old.
All are not
36.
age barred. You are. Those
You
who
are.
want to apply, they may. They will accept the application and consider it on own merit. No, otherwise they will miss this chance. Subsequently, again, we'll have to wait for some vacancies and all that. Lordship is not asking that you reserve this much of vacancy.
But I can't permit you to apply offline. Then I'll have to permit all. They'll have to issue a court origin. How can I
why
make
not?
it, make an exception for a few?
This honorable court has
Lekha,
granted such order. earlier.
I'm giving you a handle.
Yeah, it is not for them. We are
One
not-
handle in the next forum.
Yes, yes.
Mr. Upot Koorligiri, Mr. K.K. Mohanta, Learned Senior Counsel, has submitted that the petitioners who have in the meantime become overaged be permitted to submit their applications offline along with an application for condonation of the overages. Full stop. It is seen from the records that the advertisement was issued on 26/12/2023 and the respondents and the petitioners applicants have not taken any steps for submission of any application praying for condonation of their overages. In the said view of the matter, the said prayer of Mr. Mountain, A.K. Mountain, cannot be accepted and accordingly same is rejected.
My lord,
Mr. Mountain, you know what to do.
application not to be filed here, my lord. We'll have to file there.
I know it.
Condonation, this
I
court I
said
cannot.
no application for condonation of delay has been filed before the competent authority.
Well, that is, time is there.
No.
Up to second.
Second.
last day.
You fine?
Yes.
Okay, to line to cut it.
Sir,
To line cut it.
ah.
To line cut it.
Lordship may say up to 2 it is there. That is
But-
why I asked for a.
But I
handle
can't
from this honorable
I
court.
can't issue a mandamus, which is not
No, no.
practically impossible.
Only to allow us to submit with their application.
That would again create problems.
Well, that will not, because. those
You
who
make
have
your
come within
applications.
certain
Mr.
time,
Monto, I'm
nobody is
not
honorable
restraining
court.
you. I'm not restraining you. You go ahead and make your
Right,
application.
right. But then the court will not, the authority will not accept it. That is why we need a push. from
They are
the-
bound to accept, Mr. Monto. They are bound to accept.
If it
They
is
are bound
so,
to
but
accept. If they don't accept, come back. We will work out.
that will be offline only.
You can't. I can't make it offline. 26/12, this advertisement was there.
We filed this application, my lord, earlier.
It
but
came for
because of my personal
consideration
difficulty,
today.
we could not move it.
Be that as it.
Yes.
But this period, now overnight, only one day left. Tomorrow is a holiday, day after.
True, my lord. Our second is there. I can file the applications. They may keep it. So that it would pass a hurdle.
You can try with this order. I'll have it uploaded immediately.
Lordship will kindly see.
I will have it uploaded immediately. Don't worry.
All right. I'll
Listen.
try my best to get my applications there.
No. That not before me.
My lord, then the original matter, my lord, writ petition may be fixed for a date. So that,
Okay, a writ petition. List this matter again on 26/2/2024, by which time the respondents should invariably bring their stand on record by way of filing a writ.
so
by
that the
willing
matter can be
affidavit.
heard.
I'm sorry, mister. I understand, but
Yes.
I should also see
Hard
everything.
case, I don't say that it is very easy, but then, my lord, there is also an aspect to be seen, how these peoples can.
Let it be from,
Given equal
let
opportunity.
it be not an order from the division, single bench, let it be from the division bench.
My lord, there is no time to ask. Obviously.
Item 60, supplementary.
Consider 53 to material.
My lord, in order, which is state, my lord, whereby the respondent number 4 has been given the charge of the headmaster, my lord, he is otherwise not qualified.
No, it stayed. He
Yes,
has not come.
he has not come. The service is complete, my lord, on 29/12/2023, already a notice has been served.
It is seen from the office note dated 29/1/2024 that basing on the track report, the the office to put up a note, a clear note with regard to the service of notice upon the respondent number 4. Item bagged. That means they have put it in the bag. It's not received. How can I deem it?
Back.
Item bagged.
That means he has received and returned.
No. Item bagged means
It is not selling. It started from 23, I think.
item booked. It
20.
went item back, but that delivered is not there. List this matter again on 12/2/2024, on which along with us status report likhi. Let's see on the next step. You're protected. What is it? You're
They have
already
not
protected.
complied the interim order. That is the.
Huh?
They have not passed subsequent order on the basis of the interim order, my lord.
Okay. We'll see on the next step.
Okay.
Yes, Mata.
Item 53 to 55, along with item 1 of production list.
Yes, Mr. I had thought it will be, we can take it up from the, at 2 o'clock and go ahead. But unfortunately, today it could not be done. Itu my idea है.
My lord, I have filed an application for implement of, my lord.
We'll do that. We'll implement it. Don't worry. Any objection, Mr. Das? Heard Mr. S. Dotto, Lanak Senior Counsel, assisted by DJ Medi, Lanak Counsel appearing for the applicants. Also heard Mr. Das, you are there in the petition? Also heard Mr. Das, D. Das, Lanak Senior Counsel, assisted by Mr. Assisted by S. Ms. S. Sharma, Lanak Counsel appearing for the opposite party. 4-18 public writ petitioners. Opposite party 4-18 are the writ petitioners, right?
Lord, yes.
Okay. Also, the present interlocutory application has been filed, praying for including the applicants hearing as respondents, as party respondents in WPC number 6005 of 2022. Mr. D. Das, Lanak Counsel for the petitioner, as well as Mr. T.J. Mohanto, Lanak Standing Counsel, APSC, submits that they have no objections in this court impleading the applicants as party respondents in the separate petition. Also, I have perused the pleadings, perused the governments made in the writ petition, and I'm satisfied that the applicants are necessary party and a person who would be affected by the decisions that would be arrived at the present proceedings and are accordingly necessary parties. So the applicants are therefore allowed to implement themselves as party applicant as party respondent number 19 in WPC number 60005 of 2021. Full stop. The I stands disposed of. Also main expedition becomes 6005. Say it is. In view of the order passed today in IAC number 272 of 2024, the applicant, Shri.
At page 9, your lordship. Amatyo Bharata.
The page 9 of the Amartya Bhadraj is implemented as a respondent number 19 in the present proceedings. The respondent number 19, Mr. S. Dotto, or Mr. You are DJ Medi. DJ Medi. Mr. DJ Medi, Lanak Counsel, appearing for the said respondent number 19, shall file an amended cross title in the writ petition within 3 days from today, 3 working days from today. File a cross title before the registry. Also, Yes, now what?
Like- Actually, time is raised, but I have checked it, my lord. Petition was all technical.
All
Okay,
technical.
let us be honest to it, is there is no point, is all, they are all non-technical. These non-technical, they said, publish the result so far as non-technical is concerned. But I have also filed one writ petition before Lordship. And Nityananda, what is that writ petition? What is that? Huh? Ornav Kaur, another writ petition.
Not before me.
I think it's before this post. Netramani Burua is before your lord.
Natramani is there.
Yes. In that case, my lord, we sought for regulations over technical, non-technical is concerned.
But the interim order that is there, that is
Yes.
in the other case, right?
Yes, but so
That
far,
interim order
Other
that you
two
are
cases-
seeking
other
vacation,
two cases are different, my lord.
different.
my
Other two cases, they are,
I don't know why it was tagged.
no,
the
tag, my lord,
tagging-
it can be
We are
segregated. my lord.
concerned
not
with
allowing, let me
6005. No, no,
allow.
Mr. Das, we are
Yes,
concerned
let
with
me-
6005.
Yes,
And the order passed there on 18/11/2020.
yes. But this order, my lord, has been passed, but that has in connection with this, the case which is before your lordship. This is for,
Who is appearing there?
I am appearing in this case. Netramani, I am
Mr.
appearing, and one Mr. Pathak is appearing in one.
You are for?
I mean, item number 54, your lordship.
What is your case there?
For both technical and non-technical, we have challenged the we have challenged the.
You are an applicant for the aspirant for a technical post or a non-technical?
Your lordship, in fact, we are guest faculties in a college.
Okay. You will be entitled to a technical post or a non-technical?
Both, your lordship.
Both.
Petitioners, because all of them, some of them are technical and some of them are non-technical, your lordship.
Now, some opposition to
No,
Mr.
finish.
Mohanto.
In that case, they,
Some
no, no,
pressure.
no. They, in that, these other two bunches of cases, my lord,
Okay, I've seen your.
but in that case, my lord, their cases, but there is no interim order, my lord.
I know that.
They
They have no bar.
They are protect, they are 3F employee, my lord, they are, should not, their service should not be disturbed. That is the interim order, my lord.
This issue is not
They
there
are
in
paying
any other.
that is regulation.
Yes, today what to do?
So, my lord, so far is non-technical.
Yes, Mr. Das.
Well, no, one difficulty, but let me be very honest, last day also I submitted before your lordship. There's one of the case, the Ornav Kaur is not before your lordship, it's a CAB and it is challenging the whole advertisement of 2017. I don't
Yes,
know what
Mr.
will-
Monto,
I don't
in
know
that
what
case,
will be
did
the
you,
outcome.
did
No,
this
my
issue also come up?
Can I let him finish?
No, he's finished. You tell me.
Yes, I am submitting, my lord. In that case, my lord, all the petitioner, they are working as a, my lord, guest lecturer in Polytechnic, my lord, not in engineering college. They are working in Polytechnic, my lord. And in that case, my lord, in the same advertisement, my lord, engineering college, Polytechnic, everything is there, my lord. So in that way, my lord, your lordship kindly, I'll give it a petition, my lord, your lordship kindly see the pair. First
No,
pair is
your
Polytechnic.
words are enough for me.
So that is, the all are related to Polytechnic, my lord, not
Show me
engineering
the
college.
prayer there.
Yes.
Sir.
Oh, petition. Right, right.
And in fact, my lord, here in this case, in my petition, my lord, that my miss case, my lord, for allow me to declare the result, he has filed a affidavit, my lord. There is no opposition regarding, my lord, declaration of result, my lord. That is his. Now, my lord, what is he submitted, my lord, that is not in my affidavit.
In polytechnicals.
All polytechnics. Because, my lord, why I am submitting, my lord, that these are the college, my lord, they are going to lose their, my lord, affiliation. Otherwise, my lord.
But Mr. Monto, even if we allow you, that will be subject to the outcome of the case.
My lord, that is always.
Okay, where is that order which prevented you?
No, there is a direction, my lord. Your
Right,
lord
that's it.
kindly see page, my lord,
40,
page, my lord. Page 50, my lord.
53.
Sorry, my lord, page 53,
Oh.
para 21. 2021, yes. Twenty, 21, 22. Page 53, my lord, of my miss case, my lord.
Do one thing. You are here on first.
Only on first I am not here, my lord. First, second, I am not here, my lord. So can it be fixed on fifth, my lord?
Fifth. We'll pass order because
Pass
it's already
order.
4:50.
My lord.
We'll pass orders on 50th. Just hear him and then pass. I've got it. What you're trying to say. 5th, we'll pass orders.
My lord. Fifth,
I'll hear Mr. Montas
on non-technical, my lord.
on non-technical only. If he has something to say, let him have that satisfaction. You have nothing more than this. Your case
My
is
lord, that is
that
my
this
lord.
is the posts are for engineering colleges, technical, non-technical. The relief that is being sought for is for non-technical. None of the petitioners would be prejudiced
My lord.
in this, if this leave is given and that list is published, because their names cannot figure there.
My lord.
Because they are against the technical posts.
My lord.
Hmm.
And my lord, your in person to the court order, I am before your lordship. Your lordship.
I know
there
that.
is a- there is a
That's why I
direction.
just why I said it.
There are 22, my lord.
That's why the court said without leave of the court. So
that's
we'll
why
have
I'm before
to
your-
consider
yes.
whether leave, and the consideration
My
is this. We'll hear Mr. Das for 5.
My
He'll make his submissions. I'll pass the order. 5th. 5 at 2 p.m.
Okay.
You're busy people. I fix it at 2 p.m. If
No,
I
no,
take up some other matter, then it'll again delay.
Well, your lordship is proposing to fix it on 5th.
Huh.
Can it be on 6th?
No, that only non-technical.
Only
Oh,
technical,
non-technical.
non-technical.
All right.
Only on that.
Okay.
I'm not proceeding with the matter. Only
Right.
on
And
that.
your lordship is proceeding with a non-technical which my learned friend has committed to prepare. Their non-technical results would be declared. That's what is making happen. Your lordship will hear it.
Only
on
on that.
basis.
I'm
On
not
the
going beyond that.
And we have to show before your lordship that his particular prayer
Two things, Mr.
is
Das.
Yes.
One, that you will be in any manner prejudiced if the non-technical posts are or results are declared.
yes,
Two, as to why this should not be done.
yes. And your lordship will
First, I
also-
will have to have your
No,
prejudice.
no, then your lordship will take note of the other case also.
I'll not.
You know,
Because the
your-
only thing which I am
no,
before me is
Then-
6005.
No, what will happen to those cases which is
Those
checked?
cases, Mr. Kostov is competent enough. He will do what is
No,
required.
no,
to be
my
done.
case also, my case is there one more case which includes
Polytechnic.
technical, not technical,
Polytechnic.
technical, not technical.
Polytechnic.
Yes, maybe, my lord. If that 2017 advertise, I'll show one interim order of this court. How it is built so far engineering college. I will show it on.
You just tell me one thing, Mr.
Yeah.
Das. What is the main problem for you with that advertisement?
Well, the main problem is not, the main problem is there are other cases. where
Forget
I'm
the
appearing.
cases. What is your issue? What is the petitioner's stand?
No,
With
I told your lordship, this is case of technical. And my learned friend has
Okay,
come with a
technical,
non-technical.
technical,
But
technical.
selection includes both technical and non-technical. my
No,
lord.
cannot be. It has to be separate. If you can
Yeah,
show,
See, my lord,
if you can show me that both the posts were done by the same board,
No, it
sitting
is-
together, we'll do the needful.
Selection is proper. One notification was issued. Both was done. I'll show it, my lord. Let it-
Mr. Das,
But my lord,
every
there is
board,
nothing- there's nothing
every
to-
board will have to be for
And-
separate boards for
My lord,
separate
let me
posts.
tell one thing. Once you selected a notification issued that these are selected candidates, 354 selected. I come before the court. Let us pull a technical, my lord.
I am not
Technical,
worried with
non-technical,
technical.
both,
I am
my
with
lord.
technical, I am with you.
Yes. Let me
Technical,
see.
non-technical,
I'm
because
sure.
you are not eligible. That's the only
And-
lock that is there. Try to open it.
I'll
It's
try-
already locked.
I'll try.
Try to open it.
We may also be heard on that.
No, no, we're not hearing.
Tagged, your lordship.
You're not here.
No,
If you have an interim order, come.
No, my lord, these two matter, my lord, that can be segregated, my lord. This
We're
is, my
not-
lord, no
we-
relation.
Mr. Das.
No, my lord, your lordship kindly see, they are, my lord, ad hoc employee, my lord, they are main prayer is for regulation. Regulation cannot done by APSC, my lord.
Lordship, if I may kindly show your lordship why these matters were tagged in the first place together.
I am not de-tagging it.
Yes, your lordship.
It is there. So
Because
don't
the
waste
order-
your energy today.
Orders that may be passed in the IA, your lordship, will have direct bearing on these two petitions as well, your lordship. Since we are, since they are tagged together, your lordship, we may kindly be heard before an order is passed. Yes, sir.
And I'm telling you, even if the results are declared, appointments are made, I will ensure that these appointments in bold letters would contain that is subject to outcome of discussion.
Very well.
What more is it good? Because Mr. Monto's opening remarks, which caught me, is that those schools, colleges are without teachers,
In fact, my lord, that is reflected in the
Non-technical.
order.
non-technical.
In fact, what my prayer would be, your lordship, that the advertisement, as far as the learned senior council's prayer is, it can go ahead, your lordship, except for the 3 posts
against which we are seeking regularization, leaving those three posts aside.
Is there an order? Is there an order?
No,
No.
what the learned
No,
court has said,
In
Your
fact,
Lordship,
what is their right in that case, my lord? What
What
is,
the
what
learned-
the
Who
right
are you?
to
Who are you?
challenge? Who are
what
you?
the learned,
Okay, okay, who are you?
what the learned court,
You are a non-technical.
we are both technical and non-technical
Okay,
faculty members in,
Okay.
in Bharat.
How were you appointed?
Yes, we were appointed as guest faculty, Your Lordship, through regular selection process. The selection process.
Guest faculty.
Guest faculty.
So that, is it permissible to be regularized?
What has happened, Your
Yes,
has
I'm
happened,
hearing.
What has happened, Your Lordship, was there was a proposal from the Department of Higher Education that in this selection process, which is under challenge, we should be granted some weightage for the for this period of service where we have been engaged in as guest faculty. Because what has happened, Your Lordship, was
You are not given that benefit.
we were not, and what has happened,
You approached this court
yes,
after this election or before this election?
after the advertisement was issued,
We'll consider it on.
yes, deeply obliged.
If you have come after the advertisement and after this election,
No, after the advertisement,
and then what you made up, was there an interim prayer that you must be allowed to participate in the selection
no,
process
no, no,
with this?
no.
Then,
In fact, Your Lordship,
then
They are service.
that will be the final decision whenever I take,
what this honorable court observed.
you came to this court
Yes, Your Lordship.
without any interference from this court, you participated in this election process.
No, we have no, that is not our prayer.
No, they are not qualified, in fact.
Then
What we,
weightage from where this court has given you that weightage, it has not been decided till now.
that issue has not been decided,
Then-
but if these posts are filled up, Your Lordship, are
Filled
very,
up, that is a consequence. We'll see. You're
Very well.
continuing as a guest lecturer, you continue. We'll see.
very well. Your Lordship.
On that next day, you
Very
make
well.
your submission.
Yes, very well.
But
I will,
you have indicated,
yeah, very well. I will-
tentative, but
I'll,
You're watching indication. Mahanta, when you were watching indicated, yes, yes.
No,
I didn't hear
never-
that.
I never uttered.
I didn't hear that.
Ah.
Indication.
Mr. Monto, high time. You have not met Mr. Das outside for a long time. It's relevant,
No,
it's
my-
real.
We are facing problem because of the tech business, my lord.
Right.
That has to be, my lord. I am seeing, my lord, sometime another application will come, tag, my lord. That will be very problem, my lord. In fact, my lord, in some cases, there is no stay order, my lord, especially in this type of selection process, my lord. This tag matter is very difficult, my lord. Very mis-
No comments.
No, no, my lord,
His tagging business is just to extend the life of litigation for nothing.
because, my lord, if your lordship kindly see this, my lord, this petitioner, my
And
lord.
Mr. Doctor, any statement made from this side may hit you when you come this side also.
Right.
Just be careful. It's only not this proceedings.
This,
On Monday.
deeply.